These are not only a dream, breaks and schemes. Waking up at dawn, all my fears are gone. I won't stop today, never, never, not today. Step by step I go, faster than the flow. Broke through every chain, I will not be contained.
Good evening, everybody. I hope you're having a wonderful, wonderful evening. It is going to be a good one today. Good to see you, Ali Riddell. Oh, yes, good to see you, Elka. This is going to be just waiting on this thing to finish processing because it finished up, and then I wanted to update the audio on it, make it a little bit better. Hey, Wesley, good to see you. Thoroughly enjoyed my coverage of the debate last night. Well, thank you. I was thoroughly sauced by the end of the night. Sorry about that. That was no excuse for that. Let's just put it that way. So we'll try it. We'll try that again. not doing that again. So it'll be a while before I do that amount of alcohol. I finished a lot last night. Not that I'm going to stop drinking. Just that was probably too much. Just a little bit too much, man. Oh man. So what we've got? Yeah, sauced, completely sauced. I think I rolled into bed at 2 and then got back up and did a stream and was still feeling it. I was still feeling the pain. Oh man. Yeah, I'm looking to see if I've got this video. Go in here and see if I can find it. And I think it's still processing the video. Well, that's good because that'll give us some time to do some other stuff, and we've got lots on Sarah Boone today that we're going to be going over. As soon as I pull that, let's see, we're going to pull up. Go ahead and stop the screen for the time being there on that. We'll wait until this thing is uploaded. But yeah, I pulled up a lot of the documents that they had, and a lot of it's going to be covered in the hearing that happened today. It's there's quite a bit, like, because I hadn't covered this in a little bit. Yo, Daniel Berry, Sports Highlights, good to see you. Hello, Lisa, good to see you also. And I'll pull up these files real quick. 1, 2, 9, 2, 19, amended motion. Let me do this. Pull this thing out of the way here. Yeah, and then I had a bunch of other things that I had to do today, so I wasn't able to be caught up like I wanted to be. Okay, that's 927, 927, 929, 30, 930, and 2. All right, so we'll start at the very beginning of this here. I think that's the first one. Yeah, 927, 22. Yeah. Cool. All right. Pull up particular one here. And this is what we're looking at today. This is the piece that we're looking at here. And some of this we'll just skip over, hit it briefly. Basically, they just say that state received a second amended petition through the undersigned assistant state attorney. The state received the second amended exhibit list, which is the only apparent change was item 13, which was including the jail stuff, but I need to go back further. There it is. State's motion to strike defendants amended notice of intent to rely on the defense of battered spouse syndrome. So they made this motion, and this was basically I went over this last time, but I did want to bring it up. Why? why they made that argument, because they didn't want to have her using that battered spouse syndrome defense. And it pretty much, we handled this on I believe it was last week whenever we covered this. How how she smiled when arrested and talked about his death. Yeah, that woman is nuts. So, and then of course we have this one here: defendant's motion for a right to hair, cosmetics, and civilian clothing without restraint for trial. I also covered this. This one I covered last week, because basically she wanted the right to appear in civilian clothing, right to appear without physical restraints. She's been incarcerated for over 4 years, and the defense would like access to professional hairstyling, cosmetics, and civilian clothing without restraints throughout defendant's trial appearance, in respect for the court and prospective jurors. But there comes a problem with all of that. Right to control appearance in courtroom and before the jury. The courts have recognized defendant's appearance can significantly impact the jury's perception and consequently the fairness of the trial. But they already granted her the right to appear without physical restraints, allowing the defendant to present herself in a manner that does not unduly prejudice the jury, to ensuring her right to a fair trial and upholding the presumption of innocence. And while the court and Estelle specifically addressed prison attire, the underlying principle applies broadly to any aspect of the defendant's appearance that could influence the jury's perception. The defendant has a right to appear before this court and prospective jurors in the same manner as she would outside of confinement. Cosmetics and hairstyling is standard practice for presenting a professional appearance. If the individual so chooses, by extension, incarcerated males are permitted a fresh shave and a haircut. Accordingly, the defendant requests that she be permitted to access cosmetics and hairstyling throughout her trial proceeding, including voir dire. Okay, so that was the one that they had brought up. That, and then of course, hey, what is going on, Toy? Love you, Shizzy. Oh, sweetheart, you are such a doll. Here, look, this is just for you.
Hello guys, it's Jovan, and you know what time it is? Disco time.
Thank you, Toy, for the $2 super chat. Oh yes, battered spouse, my bottom. Oh well, they were both doing some spattering, and it's just the most damning is the recording saying he deserves this and laughing. Well, and that's why they wanted to have it suppressed. Yeah, shave her head and she can have all the cosmetics she wants. No, just you know, the thing is you could get her a nice haircut, or you could cut it really super short. But and she's welcome to shave too. That's entirely up to her if she wants to shave. If she wants to go clean, then hey, there's nothing wrong with that. Well, Sarah's, might have a little bit of that upper what do they call that? Peach fuzz. Yeah. So here we go. State's motion to strike defendant's motion to suppress statements at OSCSO. We also covered this last time. These were things that I pulled up because I wasn't sure if we had covered them, and because I was flying through work and then uploading a video, so I didn't get a chance to see all of these to make sure that we had completed them. But this one on 927, this was just basically saying the court could strike the motion as legally insufficient. The state objects to any additional claims being raised at the hearing that were not specifically pled in the defendant's motion. The paragraph 5 and 6 of her motion, she alleged she was detained for 14 hours, and during this time she provided a statement to law enforcement. She does not challenge the admissibility of the statement. Perhaps 7 and 8 of the defendant's motion allege that the law enforcement asked for the defendant to turn over her phone. She provided the means to unlock it to enforcement. Bell makes it clear that police haven't seized evidence from a suspect, and the suspect, knowing they have seized evidence from her, only goes toward the analysis as whether a future interrogation is custodial or a future statement involuntary. Because Miranda warnings were provided at the beginning of the interview and the following day, this was not a relevant factor for the court to consider. Oh, you got it. Yeah, that's right. Thank you for your support. Be sure to vote for me when I run for president in 2028. That's right, Puddletown. It's a man, baby. Bell makes it clear that the police haven't seized evidence from the suspect. Bell also informative on the distinction between Miranda violation and involuntary statement, which will be discussed below. Paragraphs 9 through 11. This is different from the deception that would lead to involuntary statement. The defendant received no promises of hope, leniency, or misrepresentations about the law. Both the United States Supreme Court and Florida Supreme Court have upheld that deception alone does not negate voluntariness. This represented a co-defendant's statement false suggestions that law enforcement could arrange a satellite system to put a defendant at the scene, exaggerating the amount of DNA evidence against the suspect, informed the suspect that law enforcement was investigating a missing person case rather than a homicide, writing DNA evidence on a whiteboard in an interview room prior to any DNA analysis being performed, the false misrepresentations of physical evidence that did not exist. So these are all the things they can do. They can absolutely do these things. They broke no law in doing this. It was completely proper. Luring the defendant to the sheriff's office under the guise to return her phone to her. If that is in fact what happened, does not make the statement involuntary. It only goes towards whether Miranda should have been read. Ding, ding, ding. And it was. Perhaps 12 and 13 also go towards the first Ramirez factor as to whether Miranda should have been read to the defendant. She was led upstairs to one of the interview rooms in the sheriff's office by Detective Lowen, where an interrogation ensued. Ding, ding, ding. After Miranda was read to the defendant for the second time. Nor is there coercion through the defendant. Although the defendant has not specifically made that claim or cited authority, Martin v. State, allegation of law enforcement threatened the suspect with death penalty, deluded the suspect as what she could expect for himself from a jury if he confessed, deceived the suspect as to the amount of time he had to cooperate with law enforcement, promised their favorable testimony and the use of their influence during trial if he or she cooperated, and arranged a visit for him with his girlfriend if he cooperated, and exploited his religious beliefs by relying on a version of the Christian burial interrogation technique. Did not render the statement involuntarily, though it presented the very outer limit as to what tactics law enforcement may employ when performing custodial investigations. Yeah. Although the defendant never states that part of the reason she believes her statement should be suppressed was the minimization of her Miranda warnings, nor cites any case law on the subject, stating first that she believes this is an issue to do what she has underlined in paragraph 15 of her motion. So yeah, she basically, boned herself in more ways than one. Saying this is something I have to do is not minimizing according to right. Paragraph 17 through 1 outlines she believes the sheriff offers Miranda a card and differs. So, like I said, I went through all this. This is all about the Miranda warnings. David Kospek specifically instructed the defendant on each of her 4 Miranda rights. 1, and these are the 4 that are mandated that you have to do if you're reading Miranda rights. 1, remain silent. Anything you say can and will be used against you. She had the right to an attorney before and during questioning. And 4, a lawyer could be appointed if she could not afford one. The detective then asked the defendant if she understood these rights, and the defendant said she did. She waived them. That's the waiver. Dealing with a super swollen lymph node tonight. Well, whose is it? Hopefully it's not yours. I hope the swelling goes down. Oh, man, that sucks. State v. Owens is directly on point. The defendant was read the 4 Miranda rights, asked if he understood him, and asked if anyone had threatened him or promised him anything. There's no mention of any question about whether the defendant wanted to talk to law enforcement after he was given Miranda warnings. This is apparently the federal FBI's Miranda warnings, which were described as exemplary. Quoting Florida v. Powell. The Miranda decision never contemplated that waiver of counsel could be accomplished only by the use of the words, "I'm willing to answer questions," without the services of a lawyer. There is no magic in these words. Any clear and unambiguous conduct by a person who has been advised on his rights, which indicates his willingness to answer questions without a lawyer, is surely sufficient. Therefore, if the court does not strike the defendant's motion to suppress for being legally insufficient, it should deny them on its merits. But Court believes there was a Miranda violation, then the defendant's statements are still available for use during cross-examination, but only if the court finds the statements involuntary. Will the state be prohibited from using them in cross-examination? I certify the copy, and basically says where he's located at. All this stuff is able to be shown. And then, of course, this is just a defendant's amended exhibit list. So there were some objections. Now, these were filed on the 27th. Also, went to the doctor on Friday. Be safe. Be safe. That's never any fun. I had the same thing happen to my pup. On September 26, 2024, at 7:21 p.m., the state received an amended exhibit list from the defendant. This is outside the scope of the time frame the defendant was allowed to list exhibits, but the court granted leeway for a potential extension. The potential admissibility of battered spouse evidence has changed the feasibility of all court's deadlines on a scheduling order from August 5th, 2024. See what I mean? August 5th, 2024. This goes back even further. Items 1 through 3, which defendant does not even have yet, will likely require hearsay, relevance, and a 90.403 objections to be made, result in either their exclusion or voluminous redactions to be made. Also, these records may require the battered spouse syndrome experts to have to re-examine the defendant and potentially be redeposed. Items 4 through 7 are police reports. Police reports are inadmissible hearsay in Florida. Yeah, isn't that crazy? Police reports are inadmissible hearsay in Florida. Now, if you're wondering what they're talking about, police reports, okay, that would be me filing a police report saying that Lisa, did such and such to me, and I reported her to the police. Okay. Those police reports would be basically me telling the police my side of the story. They're not admissible in court. Police report is not admissible in court. That's what they're saying. Hello, you made it. Good to see you fly on the wall. Good to see you. Hey, Mojo, I can't read this. Oh, I'm sorry. Here we go. We'll zoom in a little bit here for you. Just a second. Boom. There we go. Is that better? Can you read it now? I'm just kidding. I'm kidding. I'm so bad at this sometimes. Let's see. It's unclear whether the defendant believes she can use the reports in her case in chief or for potential rebuttal. The latter may provide some limited admissibility. Reliance on inadmissible evidence by experts is permissible, but it does not make the inadmissible evidence admissible. Regarding items 8 through 11, the state notifies the defendant that it will potentially use photograph of Jorge Torres' injuries as well. This will also involve the testimony of the deputies who observed Jorge Torres' injuries during these prior incidents. Item 12 includes inadmissible hearsay from the defendant. Item 13 is inadmissible character of evidence. If the defendant does not testify that she's justifiably deadly force against Jorge Torres on the evening she killed him, she is permitted to testify to prior acts of violence committed by Jorge Torres that she is aware of. This, however, does not allow a rap sheet to be admitted into evidence. Item 14, another police report, inadmissible 15, inadmissible character evidence, attack on the decedent's character in a self-defense case are limited to reputation for violence, evidence, and specific acts of violence which the decedent committed that the defendant was aware of. So, other words, you can't say, well, he beat his mother too, and his sister, and his dog, and all those are inadmissible. Mm-hmm. What was... I think that is too stupid. What's not admissible in court? Just about everything that they're trying to bring in. It's just not admissible. You can't admit hearsay evidence. That's what they're removing from being able to bring in. Basically, item 16 is irrelevant, likely filled with hearsay. The state has not been provided this information. 17, 18, and you have to remember that this was a list of route that they proposed, and basically all it does is go through all of these things right here, just inadmissible, duplicative, and all that kind of stuff. They also did They also did respond on this, which was for another filing that they had. Just saying, we're not going for this right here. This is April 13th, 2020. The court entered a uniform order setting pretrial conference and trial. Requires the parties to file all pretrial motions 10 days prior to the pretrial conference and cautions that late filings of motions to suppress may result in denial without hearing per state v. Powell. That means, the 10 days has been up. I mean, it has been up, I believe, last night. They do allow some exceptions on these right here. If the judge asks them to turn something in, then, then they have to. Now, 11:43 p.m. on September 26, 2024, the evening after which her pretrial conference was scheduled, files a legally insufficient motion to suppress her statements made to Deputy Kayla Rodriguez and the first two statements made to Detective Topsell and Lowen. Florida Rule of Criminal Procedure, blah, blah, blah. 2 days prior to the pre-trial conference. So this is whenever they filed. It was on September 24th. I read these all last time. We just didn't have the response. Sorry, I haven't zoomed in on every single one of these. Give me a second. I can zoom in on every damn one of them. So bad. All right, let me do this one too, or else I'll just forget, and then I won't. Yeah, we got lots of documents to go through. Some of these are pretty small. Of course, you require the defendant file the proper motion to suppress so the state can enjoy a pretrial ruling on the motion, and the jury does not have its time needlessly wasted. And then, of course, the state's objection to the Second Amendment is basically just reiterating the same thing on September 26, 2024. The only thing that was changed was 13 jail phone calls involving the defendant and third parties that were received. So there's really nothing new here, while the state may introduce statements. Blah. And then state respondment to more exhibits. And we get rid of that one because this one here is a very important one. This has to do with a motion that they made to have people brought in as witnesses. Okay. So they wanted to bring in these very particular witnesses, and it becomes very important because they're going to be arguing quite a bit of this. Well, not quite a bit, but a good amount. The defendant in her third amended witness list has listed the following people as witnesses: custodian of records, Orange County Office of the State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the Office of State Attorney, the misdemeanor supervisor for the Office of the State Attorney. Okay. The state requests a protective order under Florida Rule of Criminal Procedure because anything these witnesses could say about the defendant and the decedent would be protected by work product privilege, Florida Rule of Criminal Procedure. If the defendant wants public records from the state's attorney's office, she should do what everyone else has to do: file a freaking public records request. It's not hard. All you do is you file the records request, and you should have it in short order. Subjecting prosecutors and their staff to this type of discovery of their investigations would require disclosure of their work product and seriously impede criminal prosecutions. We believe that the trial court was right the first time in denying the pretrial defense efforts to subpoena the two states' attorneys to inquire into oral communications, sworn or otherwise, between them and a state's witness. The oral and unrecorded statements of witnesses to a state's attorney are privileged as work product and not subject to discovery. Opinion work involves a lawyer's impressions, conclusions, and opinions and theories of her client's case. Opinion work product is an absolute and near absolute privilege. Fact work product concerns what an attorney did and what she learned in her role as an attorney. As the name suggests, a fact work product is factual information which pertains to the client's case, prepared or gathered in Commonwealth therein. The fact work product is discoverable only to the parties seeking this work product to show the court the need for this fact work product to prepare a party's case, and that without undue hardship, the party is unable to obtain the substantial equivalent of this fact work product by any other means. Thus, need and hardship elements must be alleged in the motion to compel and establish to the court's satisfaction at an adversarial hearing, and there's no way that they can do that. None at all. The state is at a loss for what the non-privileged testimony of any of the people listed above could provide in the case. Therefore, the state is requesting the court enter a protective order to prevent any employee from the state's attorney's office from being a witness in this case, which is pretty damn solid, if you ask me. That's pretty damn good. And of course, they made an amendment. It just basically saying that, you know, they received another objection on the 27th, and the state's objection to this, which is just basically the same thing, just filed right after each one of them, that they keep doing it because they keep filing these. Instead of filing them as one thing, they keep amending it, and so they have to refile an answer to it. Now, here is where we get into this one, which was 929. Comes out of the state of Florida by and through Deputy Sarah Rodriguez in response to a 911 call made by the defendant shortly before 1 p.m. Think about that. Think about that. Think seriously. If she went to sleep at midnight, 1 o'clock in the morning, it's 12 hours later that she wakes up and finds his body. That's crazy. 12 hours later. Just read chapter 8. Lawyer since 2020. Now must resemble himself. Wow. Yeah. Sarah Rodriguez in response to 9/11 call made by the defendant shortly before 1 p.m. on Friday, 24th, 2020, responded to the defendant's residence. Deputy Rodriguez activated her body-worn camera while she was still en route to the defendant's residence. All interactions with the defendant were recorded. There are 3 recordings. One begins at 1:08 and lasts until 13:22. So there's 1, 2. So almost 2 hours. Almost 2 hours. Is that right? Whoa. Yeah, 2 hours. That'd be right. The next approximately starts at 1:22 and lasts 4 minutes and 56 seconds. The final one starts at 1:30 and lasts until 5:30. So 1:30 to 5:30. At no time was a defendant in anything that resembles custody for Miranda purposes. Got that? Oh my God. Between now must represent themselves. Wow. At no time was the defendant in anything that resembles custody for Miranda purposes, and so the Ramirez case outlines the famous 4-factor test. The manner which police summoned the suspect for questioning, the purpose, place, and manner of the interrogation, the extent to which the suspect is confronted with the evidence of his or her guilt, whether the suspect is informed that he or she is free to leave this place of questioning. While Deputy Rodriguez would not let the defendant enter the crime scene, the defendant's home, to retrieve a soda or cigarettes, the defendant was not in custody. So she's just not letting her into the crime scene. That's all. The deputy was the first responder trying to gather preliminary information about what might have happened. The defendant was spoken to on her porch and sidewalk area just outside her home. She was not confronted with any evidence because at that time, there was nothing to confront her with. The defendant was informed she was not free to leave the area due to the investigation, but the restraint on her freedom of movement never resembled custodial arrest. So they weren't arresting her. They're just trying to figure out what's going on. There's a big difference between they come up and they say, okay, we're placing you under arrest. And then they would have to read you your Miranda rights. She was free to walk about. If she wanted to answer questions, she's free to answer questions, which she was more than willing to. There isn't a need for Miranda. Just under 4 hours later, she was interviewed by Detective Copsell and Lowen inside an unmarked car on the scene. Although under Ramirez and Rincon, this is not custody for purposes of Miranda, she was still given her Miranda warnings. For the reason outlined in the state's response to the defendant motion to suppress statements at OCSO, the Miranda warnings were not defective and her waiver of her Miranda rights was voluntary, and her statement was voluntary. Any motion to suppress on these statements would not be granted. Certify the copy hereof, furnish James, blah, 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 on and on. And we get to the next one. So there's a amended motion to suppress statements at OSCO. Now, this here is the defendant supplying her reasoning for this. There's an amended motion. Defendant Sarah Boone was charged by way of information with a single count of second-degree murder on or about February 24th, 2020. Defendant called 911. Deputy Kayla Rodriguez. So we're just going down through this list pretty quick. Deputy Kayla Rodriguez spoke to the defendant and realized the death had occurred. They advised her superiors and scene. Sometime later, homicide investigators Chelsea Connolly, Kelsey Copesell, and Scott Lowen arrived. These two investigators would ultimately be responsible for this homicide investigation. Were involved in the interrogation of the defendant at OCSO the next day. The defendant was ordered to remain on the scene while OCSO conducted their investigation. As ordered, the defendant stayed outside of her apartment for several hours until the investigation was completed. At some point, the defendant was told to get into an unmarked vehicle with Copesell and Lowen. Once inside, Copesell recorded an interrogation with the defendant after reading her Miranda rights. That's partially reading her Miranda rights, omitting the final question, which the fourth question she was still asked because there's only 4 questions on that. But they're saying there was 9 questions and he didn't answer all 9. Ugh. During the investigation, Copesell asked to see the defendant's phone. The defendant told the detective her phone was on the kitchen counter in her apartment. The detective brought the defendant her phone and asked her to unlock it. Can you unlock it? Yep, she did. She complied with the demands of the lead investigator. Why? It would have been better if she would have claimed temporary insanity. Just saying. Might have been better if she would have claimed temporary insanity. But that wouldn't have worked. Why? Because you can't claim temporary insanity if you do something while you're drunk. Crazy, huh? You can't do that. So she wouldn't be able to claim temporary insanity if she had been drinking, because how DUIs work. Oh, temporary insanity. No, you drank and then you drove. After Copesell had the defendant's phone for a period of time, she came back and told the defendant she was taking her phone. Copesell asked the defendant to sign a form releasing it to OSCO for further investigation. The defendant acquiesced to the authority and signed the form. The defendant was told that one of the detectives would return her phone to the defendant at her apartment in Winter Park the following afternoon. Later that evening, the defendant moved into her ex-husband's home, Brian Boone, for the night. Using her ex-husband's phone, the defendant called lead detective Chelsea Copesell on her cell phone to express her concern that Copesell was not being truthful about law enforcement motives as it relates to the defendant. The defendant told the detective she believed they were trying to trick her. You're trying to trick me. You're being sneaky about something. The detective assured the defendant that they were not trying to trick or implicate her, but that the following day, the defendant needed to drive to the OCSO to retrieve her phone. The detective explained that the reason for this change in plans was because she was pregnant and not feeling well, which might not be true. Could be true. Doesn't matter. Next day, February 25th, 2020, the defendant arrived at the OCSO to retrieve her phone and had questions about this tragic event. Upon information and belief, the judge had signed a search warrant for the defendant's phone just 9 minutes before she arrived at the sheriff's department. While still under the impression that she was retrieving her phone, Detective Lowen led the defendant upstairs into the interrogation room. Detective Lowen wore his firearm on his waist during the entire event. A custodial interrogation ensued. Immediately after the interrogation, the defendant was formally arrested and charged with the offenses above. 2 hours of interrogation was recorded, and the initial dialogue between Copesell and defendant Sarah. Ooh, here's where we get dirty. Hey, how's it going, Christine? Good to see you. Roxanne, good to see you, young lady. Detective, I'm going to have you sit here in this here green chair, sweet cheeks, and I appreciate you coming in. Sarah Boone says, yes, ma'am, I want to ask about these whatever you have a moment, referring to her written notes, her pen and paper. Detective says, sure. Detective, so obviously he received his autopsy, detective. So I'm going to read you your rights again, because we have to talk about that. We're not done talking about this here incident. We just have to do it. What do we have to do? Well, we just have to do it. And then she says,
just like we did yesterday. Normal protocol?
And detective, remember, I read you the rights. Yeah, it's the exact same thing, but since I'm asking you to follow up questions, I need to read them to you, okay? So, you have the right to remain silent. Anything you say may be used against you in court. You have the right to talk to a lawyer before or during questioning without charge. If you cannot afford a lawyer and want one, one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? She says,
No.
and do you understand what I just read you?
Yes.
Perfect. Okay. So this morning we went to his autopsy and we were informed of some injuries he had by the doctor.
Where?
So he's got scratch marks on his back. Pregnant? Drank? Maybe. The interrogation continued for approximately 2 hours. At the end, while she still in the interrogation room, the defendant was placed in handcuffs, arrested. Detective read the defendant her Miranda rights directly from the printed card of OCSO. The detective omitted the final question printed on the standardized Miranda card of the Orange County Sheriff's Office. The detective omitted the same Miranda rights question that she omitted the day before. The omitted final Miranda rights question is, guess what? Having these rights in mind, do you wish to talk to us now? Not part of the Miranda questioning. And as you'll see, this is upon information and belief. It should look a little bit like this, and then of course it just goes through. I don't know where the 5 questions come from because you only have 4. 1, right to remain silent. Anything you say can will be used against you in court of law. You have the right to talk to an attorney, have him present with you while you're being questioned. If you cannot afford to hire an attorney, one will be appointed to represent you before any questioning if you wish. That's all it takes. Do you understand what I asked you? Yep. Because there's only 4 things that need to be asked and answered. Based on the circumstances surrounding these interrogation defendants' statements coerced and not freely voluntarily given, such the entire 2-hour interrogation should be suppressed. Well, not going to be. No. We ain't going to let that happen. So this is just, again, the protective order. It doesn't change anything. Just basically the same thing I read to you earlier. And then, of course, this one they filed today, which was basically the same thing that they argued before. The e-filed amend motion to suppress OCSO. Defendants reiterates the facts and arguments outlined in the previously e-filed motion, but they add some argument and citation of authority. And we're going to hear about that, about his autopsy. The aforementioned line of communications highlights the coercive nature and blah, 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 blah. That's all they did was just amend it. They left all the same stuff that was in there. What the shissiness? Pregnant and drink? No, I'm not pregnant, but I do drink. Drank a little bit. Cheers. Yeah. Finishing off that horrible beer. Not very tasty. But it's good. Good bar. Let me see if this thing is ready to be done. Oh yeah. All right. Let me bring this bad boy up here really damn quick. And we're going to go full screen with it here. Second, as soon as I can. I have to stop that screen. So that's all that was filed at the time that I did this. Even as I, as a German, understand the Miranda rights in the English. That was my best German. Let me get this thing over here pulled back up, and we're going to share this. See this you're only going to find it on my channel, and I'll have this uploaded for everybody to view. I want to make sure my closed captioning is off because I recorded it with closed captioning on. It was a little safer to do it that way. So here we go. This bad boy. Here we go. Now it might sound but I tried to equalize some of the audio down, so it'll sound funky.
I'm ready when you are.
All right.
You catch Trump, half the state.
William J. for the state.
James
Judge
Owens
is
for
really
Sarah
good.
Boone.
There we go. What's that?
I do.
Good afternoon, everyone. Ms. Boone, good afternoon. If you could please state your full name and date of birth for the record for me.
Sarah Boone.
Yeah, it's a beer.
10-7.
Okay, we're here on several different matters, including a motion to suppress.
Christine's been a member for 10 months.
the-
Welcome.
Motion to suppress defendant statements at OC.
My best German. It's let's see. See if I can do my best German I can. Como sta, pinche güero? Does that work? That good German? No, we will not try that again.
ESO filed September 24, 2024. The amended motion to suppress defendant statements at OSC or OCSO filed September 30, 2024. And then just what was filed this afternoon at 2:35 p.m. Defendant's second amended motion to suppress defendant statements at OCSO. State, have you had the opportunity to review the second amended motion? Are you ready to proceed on that today? Okay. Are there any housekeeping matters we need to address from the state side of the ledger?
Not on that motion.
And,
Okay. Any housekeeping
Yeah,
matters on
there's a
your
couple
side of the
things
ledger,
to do.
sir, with regard to those motions to suppress?
No, sir, Judge, I believe we've got two detectives outside to testify, and we've also got the custodian of records from the. Orange County
two
Sheriff's
detectives
Department relating to
testify.
the Land card and the policy.
Testify.
Is that a valid argument that you're still embarking on this afternoon based on what's in your second amended
Yeah.
motion?
Yes.
Okay, so
He's
the
barking up the tree.
sufficiency of the Miranda waiver is still at play?
Yeah.
Okay,
Yeah.
all right, thank you, sir. With regard to
what
the
they're
other
arguing
motions
right
that
now.
were set for today, the,
Oh, that makes no sense.
and I have reviewed the state's motion to strike, and I have reviewed all of the case law.
9. That makes no sense. 9. Nine ball. I love it. I love it. You guys are awesome. I'm glad you enjoy
Authorities that
that.
y'all have provided to me as well. With regard to the defendant's motion for hair, cosmetics, civilian and clothing without restraints for trial, Mr. J, do you have any position with regard to the restraints at trial portion of that motion?
Law of the case has already been settled on that issue.
Okay, all right, we'll entertain argument when we get there. And I've also reviewed the state's request for protective order filed September 30, which is also
yeah.
set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed. I've been getting some of the documents, Orange County Sheriff's Office General Order 711. I don't see any need to belabor the custodian of records sitting around.
Yep.
Something else, you actually ran the card. Or
Yeah, if you look in the very back. You look in the very.
Oh, what does that say? It says, "Hallo, ich lieben Bier, nur die Skysi die ich gerade kann man nicht bearden." I don't know what that means, but it looks cool. But if I read it backwards, it'd be yeah, something like that. Backwards. Oh my gosh, he's turned into a demon. He's backmasking his own language. Oh, you have a beer too? Excellent. Yeah. So this is a some English beer called Smithwick's. It looks like it's spelled Smithwick's, but it's Smithwick's. It's Chinese. No, and it's like a 4.5% alcohol. It's all right. It's it's not like the greatest. I mean, it didn't go well with my dinner. I guess is the best way of putting it. It's like, I mean, it's okay. Okay. I mean, I'd much rather have like a stout or a dark beer. I don't really like these ales as much, but it's hard to find anything except for ales. That's what everybody has. You're streaming from your channel on this heat hop. It's if it's okay, you're streaming from your channel on this heat hop. If it's okay with me, what that means. Like hello, love beer, but the shit I'm drinking here, you can't name beer. Okay. I don't know, from a German beer, it's not the best, but it's okay. IDA here from IDA. Yeah. I mean, the only thing I like darker ale, but like the Indian pale ales, it's like everybody has those things and I hate them with a passion. It's like you walk into the store and it's just lined up with these IPAs. You're like, where's variety? You go into a liquor store, to pick up some beer, and all they have is IPAs and Budweiser. Like, great. It's either piss water or more expensive piss water. That's me. I just don't like IPAs, what can I say? But no, I've got another one that's a little bit better. It's a Creature Comforts. I'm trying to stay away from the hard alcohol tonight because I ate too damn much last night. Yeah, and I'll tell you, if you wait, Christy, the best thing to do would be to wait until I've got the actual video up, which would be the hearing, and then you'll have the audio. Hope it's okay if you stream from my channel on this hearing. Not, I mean, I guess it's okay. I don't know if it's going to get you a whole lot of people watching. Like I said, I'll have the video up a little bit later on. It's still uploading. And after I finish the stream, I'll have that one up and running. It'll be popping out there for everybody to view. And it should have the audio a little bit better. Plus it'll have the subtitles, which should help out quite a bit. So you don't have to worry about subtitles on it. It'll also be in 20.
Very back. Okay. You see the word card? The last page is the neck of the last page.
Yeah, there's no need to keep the custodian records around for authenticity. We still have our objections.
Okay, all right. Can the custodian then be released by virtue of the state's stipulation as to that, those records?
Yes, I would tell you.
Yes.
Yeah, the Oktoberfest isn't bad at all. I mean, my favorite, it's only seasonal, is Drafty Kilt, which
I also
is
have
a
reviewed
Scottish
the 2 hour and 6 minute investigation that's pertinent to the motion to suppress. The court has reviewed the entire video. With that, state, you may proceed.
State would ask the court for the
Ugh,
clerk to mark a
beer.
identification to the DVD, courtesy copy, body worn camera.
So I can't hear what he's saying, and that he's just asking a judge. They did something funky with the audio.
And I have reviewed all of those in advance of today's hearing.
Yeah.
Any objections?
No objection.
What was pre-marked as States A will be received into evidence without objection as States 1.
Oh yeah. There you go. Oh my, oh my, oh my. Little dance, do a little love, get down tonight. Down tonight. Yes. So this is the detective, and I'll just call her Detective Hottie, because she's a cute little detective. But she was one that yes, it's definitely seasonal. I mean, the stuff that I get is called Drafty Kilt. It's made by Monday Night Brewing. It's damn tasty. Got a nice flavor to it. but it's what, 5 or 6, maybe 7% alcohol, something like that. So she can investigate a lot right now. She has no problem with that because this is the one that was pregnant whenever she was questioning her. What is the Sam Adams Oktoberfest? It's a beer. I think it could even be a lager or an IPA or something like that. It's an American beer. But yeah, so she basically states her name. She's going to come in here and give witness testimony to this. Now, she was called in, and this has to do with the Miranda stuff. So pay close attention to her answers and what the state has to say about this. This is probably one of the more important parts of this trial here, of the pretrial motions trying to get evidence in.
Yes.
Good afternoon, ma'am. Could you state your full name for the record and spell it for us?
Yes. It's Chelsea Kessel. Chelsey. Last name is Koepsell.
Thank you. Counselor, you may inquire.
Thank you. Where do you work, ma'am?
Oh, she's a cutie.
Sheriff's Office.
And what do you do for Sheriff Mina?
Got some pretty eyes too.
I am homicide.
How long have you been a homicide detective?
Over 6 years.
And what's your total experience with the Orange County Sheriff's Office in terms of years?
I'm going on 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So for this case specifically, my team was on call that week for homicides. And so on the scene, to notify the call center, to notify the on-call homicide.
All right, and is it fair to say that you guys have 3 teams of 4?
Yes.
And each of the third weeks you will be on call?
Yes.
And then through some other random distribution, it's determined who of the 4 will be the lead?
Correct.
And it was your turn to investigate the death of Jorge Torres?
Yes.
And you were notified of this on February 24th of 2020 in the afternoon?
Yes.
About what time were you notified?
So right.
I would have to look at the catch sheet to recall directly, but I would assume within 30 minutes to an hour of deputies being on scene.
All right, and do you go to the scene first or do you do anything else?
For this particular incident, I got my partner, Detective Sarah Boone, and we headed out to the scene.
All right, and when you got to the scene, what did you do?
I met with the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Did you do
Yeah, whenever they zoom in on her, you're like, yeah, she gets cuter and cuter the closer they get in on her face. Just like, wow.
a walkthrough of the scene?
I did.
And then was a search warrant drafted for the residence
Yes.
and later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes.
Do you see Sarah Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
Here on my left, and she's wearing blue.
May the record reflect she's identified the defendant.
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there. So once I spoke with deputies, I then went and introduced myself to her.
All right, and did you ask her any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened, because I've already was told by deputies what she had told them. So it's more just to like introduce myself and to let her know, we're doing a search warrant and the procedures of how we do things.
And when you respond to a scene, do you respond in plain clothes?
I do, yeah, like business professional.
Like what you're wearing?
Yes.
And when you made contact with her outside of her residence for this first contact, were you alone or was your partner Scott Lowen with you?
I believe Scott was with me.
And was he also similarly dressed in business casual?
Yes.
All right. And so how long was this initial interaction with Ms. Boone?
Not long. Maybe a couple minutes to a few minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, sitting out. There, like,
Venus de
front
Milo with
porch
Rosie
area.
O'Donnell.
You call what you asked her in this initial contact?
Do I recall what?
You asked her?
Yes, that is true.
No.
Okay. So it was just a couple of minutes that you were there with her?
Yeah.
Okay. And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else. And then once that was executed, we went in there further with CSIs. And then we talked to Brian Boone, which was the ex-husband. And then I believe we then sat Sarah into our unmarked vehicle and had a conversation with her.
Was that conversation in the unmarked vehicle recorded?
Yes, audio.
And can you describe this unmarked vehicle for the court?
At the time, I was in a unmarked Pathfinder, so it was like gray in color. Didn't look like it didn't say like law enforcement or police or anything on the exterior. And there were lights like in light inside.
Where did everybody sit in this Pathfinder?
I sat in the driver's seat. Sarah sat in the front passenger seat, and Detective Scott Lowen sat in the back seat.
Did you have any conversation with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
There you go.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview on that recording, did you not? Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for 911?
Yeah, I would say, yeah, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Ms. Boone?
Just based off the situation and what was happening.
Okay. Is it in any way unusual to gather evidence before talking to the last person to see a decedent alive?
No.
At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was
And when was that?
that same day.
I mean, when time-wise in relation to talking to her?
Oh, well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSIs documented everything, photographs. So I don't think I really touched it until after I had to talk to her about going through it.
Are you missing his Vera
All right.
doing the voice?
And ultimately, was she placed under arrest on February 24th, 2020?
Are you missing?
After she got out of her car, was she free to remain on the scene or free to leave?
Oh, see there see now this is why I wish I had Yamaha in here. Because now Yamaha, he has a perfect German accent. He does. He totally has a perfect German accent. Maja, I think it's Mao. I'm not sure if the J is pronounced. Could be Majo, like Mary Jo or Majo, or probably something I can't pronounce.
I go back in her house.
Prior to that, had she been detained and requested not to leave the scene?
Right, one more time.
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
Not by me.
February 25th, was there a second
Hey, Diane
interview
G.
conducted with you and Detective Lowen with Ms. Boone?
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the sheriff's office?
Yes.
And had you reviewed some of the evidence on there? You had requested that Ms. Boone come down to the sheriff's office rather than you returning to the scene.
Yes.
Can you explain that?
It's more of a controlled setting for law enforcement. We were able to audio and video record at the sheriff's office, and she had mentioned that she might not be staying at her apartment, and
Don't blame her.
I didn't want to go to the ex-husband's residence where her potential child was. So I just felt it was a more controlled setting at the sheriff's office.
All right. And when Ms. Boone arrives at the sheriff's office, who goes down to greet her and where?
It was not me. But she would have gone in through, we have 2 entryways. So either on the record side or on the opposite side. And
Yes,
she
she
would have to
gets
go
my
up to the window
schnitzel
and request
moving
that she was
too.
there to meet with me. They would call me. I would tell them yes, sign her in. And then if
I
I'm not
wonder what she
mistaken,
would detect on
believe
me.
Scott, Detective Lowen went down and got her.
Yeah.
All right. So you're describing 2 separate entrances that members of the public can come and go through,
Yes.
as opposed to separate entrances that might be in the back of your building where people are not free to come in and out of without a swipe card.
Yeah. Probably doesn't make sense.
All right. Now, in relationship to those 2 entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or the investigation division's interview rooms?
They are located upstairs.
All right. And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with the sheriff's office.
And your testimony is it wasn't you.
I don't believe so, no.
Now tell us about these interview rooms.
We have 4 interview rooms that are audio and video recorded.
Okay. And they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the sheriff's office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have other questions of this witness.
Thank you. Any cross-examination?
Yes. Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent
Sounds like
Sarah
he's
Boone.
got gas.
Detective, have you had a chance to review any papers?
So now James Owens is is Sarah Boone's attorney. Now he's going to start asking her some questions. Her answers are chef's kiss. I'm sorry, that look right there, just all I can see whenever she gives that little look is just like a couple of little bite marks right there. Like, looks could kill. She could look at me like that all day.
Paperwork related to this case prior to this hearing?
I have looked at my investigative report and I have looked at some policies, but they were from Current.
All right. Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for
Ja, ein pumpernickel quivers mit excitement when she glares at me. No OnlyFans or Instagram. Dang. You don't need it. Baby, lock me up with them handcuffs, baby, and treat me rough. I won't sue.
this interrogation with Detective Lowen, that you did a preliminary investigation
now, doesn't it?
as to whether or not this was potentially a homicide.
Just imagine a day at the beach with her. Smell of baby oil. I can tell already she wants me.
Yes.
And you would have viewed the scene inside the apartment?
Yes.
That's the grassy knoll.
And
I
you would have
wasn't
spoken
born
to
yet.
Deputy Rodriguez about what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian.
And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Well,
Potentially. I didn't listen to that interview. I don't know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
At some point, yes.
I misread that, bad duck. I thought it said that's not a grin in my pocket. It's a cannon, baby. You do it better, Tunkoff.
Tell us when that happened.
The next day.
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult to the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation. But due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then pending, once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another
Gun's digging
interview
into my
with
hip.
her where she was Mirandized and she went to jail later that evening.
And while you were there
Yeah,
on
I didn't
scene,
know the name
I know at
Pumpkin
some
Nickel.
point you saw her phone on the kitchen counter.
I did.
All right.
Or maybe
And-
on the microwave. It was somewhere in the kitchen.
All right. And at some point you went to Sarah Boone and
Pump her nickel. I'll pump her twice for a dime. Pump her nickel. Come on. Sorry. Don't cough. We keep cracking at it. Mojo, when you hear his German accent, you'll think your daddy just came home to meet you. It's so true. It's so true.
You asked her for the password to
Whatever,
open the phone.
dollar.
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form? Sarah, give me the password to your phone.
Not that I
Give-
recall, but I would normally
Give it
have her
to me
sign
one more
the consent form
time.
first for her consenting to go into the phone and then gather the passcode or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to searching the phone?
She called 911. So I told her that we needed to corroborate her story as to what occurred. And so to do that, I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene.
Maybe before you bump. just
Was it
like
prior
gas
to
station,
her
baby.
interrogation in the unmarked vehicle? And after she signed the consent, your testimony is you asked her for a password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right, you're talking about the digital investigator? And they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh yeah, she didn't come until later. I believe
No, don't pump her, Nickel. Pump her. Never mind. We won't say that.
around 7 p.m.
Okay.
That's when in the CAD sheet it says she arrived.
And you know, there were two videos on Sarah's phone.
My
After.
terminology. My mind, it makes
I'm
sense.
sorry?
After I spoke to Sarah,
All right. So what I'm gathering from what you just said is at some point you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
I don't know. She could put me in an unmarked vehicle and interrogate me. I'll tell her everything she wants to know. Check your Discord there, Yamaha.
where we completed an interview, yes, sir.
And your testimony is that you did not view the videos that were found on her phone. And I'm referring to the 2-minute video of George in the suitcase. And then some time went by, and I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
That's correct, sir. I did not go through her phone until digital forensics came out and then went into her phone. And then she brought me over to her van to tell me about the videos and what she found.
All right. So your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived.
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in the vehicle?
Of course.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a conversation with her. And once I walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question.
Sustained.
Yeah,
Your
this is
testimony is you don't
improper
remember
question.
saying that.
I don't remember specifically saying what. One more time. What is it that she claimed that I said?
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would
Okay.
interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car?
Yeah.
Standing?
Yes.
No.
Well, you would have to tell her something.
I said, yes, we're going to go have
Saw
a
your
conversation in
wreck.
my car now.
Okay. And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you
All of
agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat when we were going to talk.
Front
Yeah.
Your
Okay.
seat.
And you don't recall whether or not you said this is routine protocol to come into the car and talk to me?
Those words specifically, no. But I would
Yeah.
talk to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
All right. Now, once inside the squad car, you were there with the other detective, Detective Lowen. Okay.
Yeah.
And you read her the Miranda rights card, correct?
Yes, from my part.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance.
Response.
Judge, we're here on a hearing on the issue about the interrogation.
But the case law that you provided to me, none of it stands for
Stay
the
with your hair some
proposition.
more. Just
Miranda identifies the 4 things that need to be addressed. Not one of the cases talks.
and here is where the judge is about to go off on this attorney. Listen really close to what he says, because this is very, very important. Very, very important.
But the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is in the motion upon information and belief. This is what it says. So how is it relevant for the purposes of today?
Well, it's relevant because this is the policy of her department.
But
Judge,
what does the policy have? But now we're getting away from the card to now the policy. There's nothing about the policy right now. The question is about what the card says.
the card is the policy, and the policy is the policy. They're intertwined. They refer to each other. Our argument is that she did not waive her rights.
But
Remain silent.
That's a different issue than what is on the card.
I understand, but it's a coercive question about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
On February 24th or on February 25th?
On February 25th, this interrogation ties into that one. She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights, and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider as to whether or not that statement should be suppressed.
Any other response?
Well,
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida, or the United States and federal case law and the state case law interpreting the United States Constitution, the policy is irrelevant, and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant. And I would.
oh my God. You guys are not going to believe what just happened. What just happened? Wow.
It's no big deal.
That's about right.
No big deal. Oh, brother. Oh, man. Yeah.
Oops.
Yes. So Majo.
What's up?
Majo wants to hear your German accent.
My German accent? Well, what are we going to be talking about? Apparently everybody's interested in my little pumpernickel. But you see, the girls, they got a taint, and the boys, they got a pumpernickel. And I don't care what Puddletown says, that's the way it is in my mind, once that's the way it is.
He said that Cole says, I love your pumpernickel bread.
Oh, I love the pumpernickel.
Not in Westfalen. That's awesome. That's awesome. Good to see you. Yeah.
Yeah, you too, man. Yeah. Oh, don't start spelling stuff out. I can't read that fast. I'm just kidding.
Ich bin Platz. I don't know. He has a German accent, but I don't think he speaks German.
It depends.
It depends.
It used to depend on how much alcohol was involved. I mean, you'd be surprised how fluent you can become in various different languages when you're drunk. Sober, it's hit and miss.
It's hit or miss, exactly. Oh man. Well, we'll get back into this here. This is cool. Anytime you want me to pause, just let me know and I'll pause.
Oh yeah, no. I mean, this was something that because I had caught part of this earlier when I was passing out, and in between the hallucinations and painting, where they're talking about this whole part, whether or not they met that. The only thing that has been mandated by the Supreme Court is the fact that the Miranda warnings are read. And their policy, Florida Constitution, none of that supersedes in any way, shape, or form. So it doesn't matter. It's irrelevant. This guy's just throwing shit at the wall to see what's going to stick. Is what it comes down to.
Exactly, because there's four things that you have to have for Miranda warning, and they met all four of those.
Yeah,
he's like, question number 9? I was like, that means nothing.
Yeah.
Because he's like, well, this is what I suspect it should say. What does it matter what you suspect? Was the burden met? And the burden was met in that. So you can piss off elsewhere.
Right. And even in writing down, because that was the other part too, and I can't remember if he's got to that point yet or not, in regards to the waiver form itself. That in and of itself is not even a requirement. A lot of places that's just basically a formality, part of the paper trail, part of the evidentiary proceedings, and you're not even required to have that. So whether or not that was done is irrelevant. When somebody starts making spontaneous or excited utterances, it would behoove you at that point in time to stop them if they have not already been Mirandized and advise them of that. But prior to that, their spontaneous utterances can still be utilized.
Yes.
It's after that it then becomes questionable, and you continue to further question them. Out in the field, I had never had a waiver signed. It was always just reading of Miranda. I was only involved in 2 specific interviews or interrogations, but I was a nothing. I was just sitting back. I wasn't lead on any of that. So I never had to have him sign anything. That was whoever the lead investigator was. So, yeah, it's just in many cases a formality.
And it also goes to show that whenever they're asking you these questions, even if you have the excited utterance, if I'm sitting there reading you your Miranda rights and you say, I don't agree to any of this, and then you continue saying the same thing, that's going to be used against you in court of law. Yeah. Just because you say, I ain't agreeing, I ain't talking about anything, and then you continue saying the same thing over and over again. You did X, Y, or Z.
Right. Well, it becomes a magical term, I think, is what even Sean utilized, that the magical word or the safe word or whatever it is, wanting your attorney. At that point in time, it's dumb, not to say that it hasn't happened, but it's dumb to sit there and continue to try and question somebody at that point in time. But yeah, spontaneous utterances can still be utilized. So
that's awesome. Pumpernickel got its name because it's baked from whole rye meal and therefore causes flatulence.
Yeah. There was something else to that too. I can't remember.
Get you drunk?
Anyway, no, fucking something about fart goblins or some shit like that. Some crazy thing is some weird thing like that. I can't remember exactly how that went, but yeah, something along those lines.
So when you pumpernickel, you're farting.
Yeah.
Oh, that's awesome.
I would ask that we honor the local administrative order and call people by their surnames, not their first names.
Yes.
What matters is that
that pissed him off.
Was read what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both parties.
Let's bite the apple. I'm sorry.
Last bite at the apple. Last bite at the apple. Any other argument?
Judge, we're talking about the totality of the circumstances, whether it was coerced or not. You can take any technique or a non-technique, something that you use or don't use, to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning form? Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring about surname. What do you mean by that? You mean,
That means last name.
okay, what did I say?
Keep calling the defendant by first name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone. That's fine.
Okay.
You may proceed.
There we go.
Have you had
Yeah, he was just, he's just being right. You keep calling her Sarah. That's too formal. We're not doing that. That's too informal. We need to be a little bit more formal and appropriate in a court of law. It would be like me calling you Mr. Biker, or you calling me, idiot, or Mr. Idiot. You, it would be inappropriate for you just to, like you could call her Miss Sarah or something like that, as long as people recognize it the same way.
Right. Yeah. Especially for the record. Yeah.
Yeah.
Because that can get confusing because in theory, you could have half a dozen people, suspect, witnesses, whomever, named Sarah. So, yeah.
Yep.
It does need to be defined.
And then if you get a witness in there, say her name is Judy Boone, you would call her Miss Judy Boone.
Yeah.
Something of that sort to differentiate her from Miss.
Right.
a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office? Do you agree that you did not read the 9 questions to her?
Objection.
All 9 questions?
Correct.
No, I did not. No, 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my Miranda card.
I'm sorry?
It's not on my Miranda card that I read.
What do you mean by that? It was the card that you read, it was not on the card?
Number 9. We have multiple Miranda cards at the Sheriff's Office, but yes, that is the in reference to the policy. Yes, it is a policy.
Well, somebody dropped the ball somewhere. Did you fail to get,
Sustained.
did you fail to get the most updated card, or how did that happen, that the 9th question was not on your Miranda rights card?
I've had that card since I started sex crimes. 20.
Have you become aware, as it relates to filing this motion,
I've been more aware, yes, of that card.
have you gone and gotten the updated card?
Objection relevant.
Sustained.
Gosh, she's so cute. Even when she's frowning, I want to make her cry. Got pretty eyes too.
Yeah.
When y'all took her phone, Detective, did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her phone back? You did not tell her that?
No, I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had plans to meet at the Sheriff's Office.
Or tell me what you understood the conversation was.
That is a slap down right there.
Yeah.
So she's saying, I never told her that I was going to bring the phone to her. We always agreed that she was going to come down to the sheriff's office. Oh.
Yeah, there's a little conflict going on with, pretty much anytime Sarah opens her little cock washer, it's full of bullshit and lies. So
that's very true. Well, and here's the thing, Lisa, even if she brought the microphone closer, it wouldn't change what's happening with their audio. They have a noise gate on there, and it's completely jacked up. Even whenever Sarah gets up there, it does the same exact thing. They've got that noise gate on there where it's closing up as soon as it picks up any sort of volume. I don't know why they did that on that microphone, because the judge's is completely screwed backwards from that. So as soon as he starts talking, it's like this loud volume. But yeah, with her, they've got a noise gate on that thing that keeps shutting it down. And nothing I could do about it. I wish I could have. It's just impossible to get it louder.
relates to her getting her phone back?
I'm sure she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that, I don't even know if I told her that I decided to write a search warrant on it because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, so I took it. And I wrote a search warrant for it.
Okay.
Yeah.
But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone to them.
Okay. Do you recall her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Oh,
Yeah.
Oh, oh,
Oh,
We're
well,
talking
Sarah
about-
said
we're
it, so it must be legitimate. I mean,
We're-
you know.
we're talking about the alcoholic that can't remember putting a guy in a suitcase and goes to bed. We're going to believe her, and it's her testimony. Oh, because he's like, do you have documentation of this? Well, if it was her husband's phone, you should be able to go back and pull up the record that he called that
Right.
that number was called using his phone, because that's what she said. Man,
Mhm.
oh, I didn't get that the first time around. I had this playing in the background while I was working.
Yeah.
well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about.
Thank you, Megan.
Yeah.
Dog shite. Scheiße. This attorney stinks. Yeah. Yeah.
Well, he kind of I mean, it's kind of one of those things, you know. I mean, we make fun of these guys, and some of them, you can see where, oh God, what was her name? The one that whacked her husband 4 times in the back and all that. Now, her attorney, that was above and beyond just trying to work for your client. He was a complete and utter shitbag. He was just a piece of shit.
Yeah.
The guy in this case is trying to, like we've already said, throw shit at the wall and see what sticks. He kind of has to, because if Sarah doesn't think that even if they sound like stupid questions to us, it's going to start this whole thing all over again about her firing him and just trying to delay and delay and delay. The shit should have been taken care of a while ago.
Well, and the judge has already said, even if she fires this judge, she's representing herself. Like,
Right.
good luck.
I know.
Like,
But it's just her
it's not gonna stop.
continuation of the same shit over and over again. It's just so I can't read his mind, obviously, but I think part of it is he's trying to avoid that as well.
Yeah.
So he's not as bad as that one lawyer that I just referenced, but oh man, that guy was horrible. There's doing stuff for your client, and then there's going above and beyond just being a shitbag, and that guy was a shitbag.
Yes. Yeah. There's a few of them out there, or being a shitbag prosecutor.
Right.
You know,
right.
that one right there.
I mean, it goes
is
both
pretty-
ways. Yeah.
Yeah, because we've seen the shitbag prosecutors, and we've seen really good prosecutors.
Mhm.
I mean, what was it? Edgecombe, the prosecutor, and Judge Borowski. Oh my! Just like Edgecombe, the guy that shot the attorney. That was he was a immigration attorney.
Oh, I didn't.
Claimed that this guy called him the N word, and then he rode up to him and punched him.
Right.
Yeah.
Right. Yeah. Okay.
Yeah, I
Yeah.
can't remember that guy's name. That attorney.
Yeah.
The race grifter.
Mm-hmm.
That guy.
Yeah, I remember that. Yeah.
What a shitbag he was. Started quoting Johnny Cochran like it. He was,
Oh, jeez. Yeah.
yeah.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
Didn't have this conversation.
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right. So you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you.
Something along those lines.
Okay. And when was it that you actually saw the 2 videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
Yes, it was happening.
All right. And was it while you were on scene? Okay. And did you attempt to talk to Sarah again about that at that time? Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection relevance.
Yeah, this objection.
Did you let your partner know about that evidence? Okay. And did y'all discuss that issue?
Objection relevance or product.
Sustained.
At some point, y'all had to, were y'all working together, or were you making all the calls, or were y'all making joint decisions?
Objection relevance or product.
Sustained.
Ma'am?
There's no pending question at this time, ma'am.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself, or was it collectively made by others within the department?
Objection relevance.
Sustained.
Yeah.
You don't need to answer anything.
No,
Detective,
don't
at what point did y'all, that next day, I think you had her coming in the afternoon?
I believe it was on 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone, and I believe I submitted it that evening. I would have to look.
Okay. Do you know what time the search warrant came back signed by the judge?
Mine's done. That's the report, but I don't know.
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
Yes.
Okay. Would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
Yes, I did an autopsy in the morning. That's why I asked her to come in at 3.
All right. And what time was the
Yeah, I'm probably going to cover that tomorrow morning a little bit in the morning news, because that's a pretty
That'll be
crazy one.
interesting. Yeah, that'll be interesting if some of the allegations or potential thereof, based on the preliminary hearing, is true. And that it's hard to say, because we don't have everything. We don't know everything yet. So the trial in and of itself will be very interesting, and the evidence presented therein. But at this point, if some of those allegations are true, in that moment in time, if all of a sudden the realization hit me and that were my supposed underage daughter, I can't recall how old she was at the time. To my knowledge, she was underage, and I believe she's still under legal age. I can't say that I probably wouldn't do something like that either, if it is what the allegations are. But that's where we have to, because everybody's different. Think, they're a cop, they should know. You never know what's going to happen when you're put in a situation like that, unless you've actually been there.
No, I mean, there was a good friend of mine that it took about 10 officers to hold him down from what he found out about his niece living in another state. Like, they had to take his keys away from him and handcuff him, because he was ready to leave at that moment and go handle the situation of something that happened to his niece.
Sure.
Yeah. And yeah, just it was unacceptable. It's just like the way that people react, you never know.
Yeah.
Some people will just go, all right, they go into the certain mode of, we'll do everything we can to arrest them and get them locked up. But
then when
there's other people, they're just like, they just snaps. It goes.
Yeah. And that is a perfect case, even in that situation, because on the outside looking in, as the sheriff or as a road deputy or as a police, whatever, and you're looking at that type of a situation from the outside in, you could say, oh, no, let the law do its job. We'll arrest, investigate and then arrest, whatever it is, and follow all the little dominoes. But all of a sudden, when you yourself are personally thrown into that situation, it's your loved one, your parent, your child, whatever it may be.
Yeah.
Your train of thought isn't necessarily going to be on that professional level. And like you said, you can just snap. So it's hard to say. It's real early still at this point, because like I said, that was just the preliminary hearing. So we don't know what all's there yet. And they
No, this
still
did not happen in
hadn't
2020.
got all
This-
the reports
this-
right.
Let's
has
put
only
it this
been
way. This
11 days.
happened, 11 days ago.
Mm-hmm.
This happened 11 days ago, and they
Yeah.
just had a preliminary inquiry on it. And he pleaded not guilty.
Yeah.
So,
Yeah.
I'm very interested in what that one's going to turn up. But like I said, that's going to be for tomorrow morning.
Yeah.
It's going to be probably a darker morning. Great. That's all I need.
Autopsy that morning.
It starts at 8, but I didn't probably get up till 10. It takes quite a few hours.
Okay, and were you there alone with the medical examiner, or were there anybody else there?
I don't recall if Detective Lowe was with me or not, but yes, of course, there's doctors.
Okay. And so, in
Sophisticated.
terms of
There you go.
your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the 2 videos from her phone the day before the autopsy?
Objection, relevance. Custody is not disputed on February 25th. statement.
How's this relevant? If the issue is knowing and intelligent waiver, the sufficiency of Miranda and coercion, what does the formulation of probable cause have anything to do with anything?
Oh, I'm sorry. I might have misunderstood. So we're talking about this case here. Yes, this particular case, Sarah Boone's case, it did happen in 2020. Okay, sorry about that. Okay, so here in 2020, Sarah Boone was playing hide and go seek with her boyfriend, and he was inside a suitcase hiding, and then she videotaped it mocking him. And then went to bed drunk, woke up 12 hours later, called 911. By then, I think he had a true stiffy, and was pronounced DOA. And she has gone through 9 attorneys. Not all of them were her fault. Some of them represented witnesses, or they represented the decedent. So they excuse themselves from it, but she's had, I think, 4. This is maybe attorney number 5. So the first one, I think the first one couldn't do it. The second one ended up being an actual attorney like this guy is, not just working for the state. Had his own practice. She was paying for that. And then of course, hey, how you doing? How you doing? Good to see you, expert. Good to see you, brother. And the blueberry beret.
Yeah, see, that's another example of spontaneous utterances or admissions. Yeah. Anyway.
Yeah. So this is won't mention that.
Yeah. Yeah, just throw that grenade and run. There you go.
Exactly. That's what we do these days, isn't it? Scheiße. But yeah, so
and Puddletown, whatever.
Yes, and Puddletown, because I'm a real friend.
Too late to play innocent there, pal.
Yeah, this will get as they're not allowed to introduce any of that as evidence. That it's just been a shit show getting her representation. And it ended up being that the judge finally put a kibosh on it and said, this is the last attorney that we're going to get for you. If you want to hire an attorney, you're welcome to, but we're moving on. October 7th is our court date. This is when we're having the court date. I think he booked it up for 2-3 weeks. I think it was 3 weeks that he set it aside for. So he set aside 3 weeks, complete the case. And we're not playing any more of these games. If you have an attorney, cool, but we're not stopping this from moving forward. So anything that they have to file, they're going to have to get it done pretty damn quick. And then this guy came out of the woodwork and came in, I guess, from Tallahassee. I think he's where he's from, or Pensacola, or some crap like that. And so he went all the way to where she's at to handle this. We are.
Yeah.
Well, I wanted to bring out the fact that they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her. So that if she, A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway. That they had already made a decision that she was the prime suspect. They had probable
What does
cause.
that have to do with any of the 3 issues that are raised in the motions?
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
My response
That's my understanding. The state's not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So Miranda was given on 2 separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day.
Hang on. Before we ask any questions, let's deal with the evidentiary objection first. The objection sustained.
Yeah.
Okay.
You may proceed.
All right. Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave?
She was not.
Excuse me?
She was not going to be free to leave. No.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway. And that was based on your investigation that you had the night before at the scene. It was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the 2 videotapes that you saw from Sarah's phone.
Uh-huh.
Well, I think the video speaks for itself.
Sustained.
Well, that's what he's trying to get thrown out.
You had all that information before you began your.
Well, and see, that's the thing. He's wanting to get the video thrown out.
Right.
But see, here would be
Statements
the thing.
and video. Some other people have said, no, I don't think he's trying to get the video. No, he's trying to get the video thrown out as well.
Yeah, he's trying to get all statements, all video.
Which is just,
and if he can get those thrown out, then they say, well, then they have no case. And he would,
because they would have been stupid, to put it honestly, at that point in time, especially with the videos, to say, oh no, you're free to go, and just let her fucking walk out. No, that's dumb. You don't do that. I mean, you got the video right there. That's all I would need. Screw everything else. All I would need is that video at that point in time. Whether you have the autopsy or anything else to go along with it. Personally, I want to hear the medical examiner in that portion of the trial, because that stuff from the medical side of it is always of an interest to me, as well. But my personal thought and opinion is, I think he sustained the head injury of what they speak in its limited format thus far, because she got him into that suitcase and luged his ass down the fucking stairs.
No, that's not what I understand.
But I don't have enough left to go on that. I don't know if she actually whacked him in the head or what the deal was, but that makes perfect sense to me, because she certainly didn't carry him down the stairs.
Well, no, he was already downstairs. He was already downstairs.
Okay.
Like from what they were saying.
I was under the impression that they were upstairs, and then she just
No, from what my understanding is that they were downstairs. They had cleaned out like one of their closets, and they were getting ready to toss all this stuff or take it, donate it or whatever. And for whatever reason, they were playing hide and seek. I don't know, because she's really confusing, like, because she doesn't tell the truth.
Right.
So from what I gather is after this little hide and seek escapade, they had been drinking quite a bit, and then she just went upstairs and went to bed and went to sleep and got up the next morning and then called 911.
Right.
Okay. Now here's sort of my thought, and I put this lawyer disposes of this waste properly when he's done. I think and I'll say this in all honesty, I think that she got shit-faced drunk, like blackout drunk, did all of, he was probably just as drunk, locked him up in his, he crawled in the suitcase, and she was just like, it'd be funny, I bet you can't fit in there, and he crawls in there. And then she zips it up and is laughing at him and going, ha, 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 asshole, I got you. But I think she is so wasted, she did not even realize what she was doing. Because she's a tiny little thing. And they went through, I think, 2 bottles of fucking wine. Like, I think she was absolutely shit-faced drunk and just, like, made fun of him, mocked him, does not even remember. Because if she would have known that she recorded that, why would she give that to the detective? And I think she just took her happy ass upstairs, went to sleep, and had no idea these recordings were on there. I would almost guarantee that's what happened. The only problem is she can't plead insanity. She can't do that because it wouldn't work. It's the same way as if you get a DUI, you run over a bus load of nuns and don't remember doing it because you're too drunk. You can't plead insanity. It's like, well, you should have never gotten in the car.
I don't buy that she doesn't remember.
No, why would she give her phone up to him?
Yeah.
I mean, that
because
makes no sense whatsoever.
But from what we've seen from her as well, whether intoxicated or otherwise, she's not exactly the brightest bulb in the box. So my thought and feeling is that she doesn't think that there was going to be anything to criminally implicate her in anything, because there's nothing on the video that shows her shoving him in that suitcase. There's nothing that shows the trail of how he got, to my knowledge, unless there's something that they find that was deleted. And potentially maybe there was, and that just hasn't come out yet. And she thinks that it's gone, but maybe they've been able to recover something. This is just preliminary stuff. We don't know that. And so I'm thinking that in her mind, she doesn't think that there's anything that can criminally implicate her. Oh, okay, yeah, I'm sitting there laughing at him, making fun of him, blah, 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 blah. And so she thinks she's going to get away with this. That's how I'm seeing it.
Yeah. Yeah, it's a possibility. Yeah, but you also have to understand she's at that time. I mean, she's put on quite a bit of weight. At that time, I think she weighed.
Yeah, she was a little bit.
90 pounds wet.
Smaller then. Yeah.
Like 90 pounds soaking wet. I would honestly say that she's a tiny little thing. I don't think she's like 5'2" or 5'1" or something like that. Yeah. And that's like 2 bottles of wine. 2 bottles of wine. I plead I drank a fifth. But that's only 2 bottles that we know of. She could have been drinking all day for all we know.
Right. Yeah.
I mean,
and this is why a lot of this stuff that we talk, you know, and we say stuff and we have all this supposition and all these things and joke and blah, blah. You know, up at this point, like I said, this is just preliminary stuff. We don't know. And so that's why I don't care about the joking and some of the suppositions.
Oh, exactly.
I mean, some of this stuff, when we see it on, you know, the true crime side or whatever, some of that stuff gets a little ridiculous and out there.
Yes.
And you can tell a lot of those people are people who are not actually ever actually involved or have worked within that area with some of the things that they say. But that's why the trial portion is so interesting to me, because then that's when everything is at its culmination and is coming together. Now, certainly things happen. All of a sudden there's a new introduction. There's some other type of extenuating circumstance. But for the most part, once we get to the trial portion, that's where it's at its culmination, the apex of, okay, now
we already know that she was, we already know that she was a massive alcoholic. I mean, that's already known. That's what caused the divorce with her first husband, and he made that very clear. He said she gets aggressive whenever she's been drinking, and you know she just becomes more of a pain in the ass. Most of the arguments between her and George whenever she would be drunk, like she would attack him, he would attack her, and you know it was all about who got to the cops first. 2 glasses of wine your limit, and I'm 5'1". Yeah, try a couple bottles of wine that we know of. That we know of.
Your interrogation on the 25th of Sarah Boone.
I had all that information.
All the information that I just related to you before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th.
Objection.
Overruled.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to George Torres from the autopsy?
Relevant.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
And you also wanted to question her about the 2 videotapes that you had found on the phone?
Yeah.
Relevant.
Overruled.
Yes, I do want to show her the videos.
And you agree, in your opinion, the 2 videos, and the autopsy were inconsistent with the story she had given you in the squad car the day before?
Objection.
Overruled.
The videos, I'm sorry, repeat your question one more time.
You would agree that the autopsy results and the videos that were extracted or taken from her phone, recording George, those 2 pieces of evidence from your investigation were inconsistent with a statement that she had given the day before in your squad car?
They'll says to see you.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection. Irrelevant.
Sustained.
Now, you said you had a chance
I would
to
say the video
review
did that.
the
I'm going to have to go back to
interrogation
the video on
at
this.
the Orange County Jail on February 25th of 2020.
You only
Orange County-
arrested her
Orange County Sheriff's Department.
because you
And
thought
also-
she was lying. No, it was more the video. I'm going with the
more-
video on this.
Yeah, I would say more the
Nice
video.
try, counselor.
Yeah. Nice try.
Yeah.
So I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video and audio.
Okay, have you?
I cannot wait until they call her up on the stand.
Oh, yeah.
Ah,
You mean now or in the actual trial?
anytime.
Yeah.
Anytime.
Yeah.
Just call her up on. Just call. Especially whenever you see her, whenever she's standing up, you're just like,
Yeah.
Hmm.
Well, they
You had a chance to look at my motion.
They need to hire a pooper scooper for the courtroom because it's just going to be filling up with bullshit all over the place.
oh yeah, yeah. Not her though.
I have not read the transcription. I watched the video and audio.
Okay, have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I've not looked at the
Okay. Do you recall you saying to her, I'm going to have you sit in the green chair?
Objection. Best evidence is the recording.
He's right.
Okay.
Objection sustained.
Okay. Do you agree, prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you...
Oh, and also, I think I'm going to take notes from somebody else, and any super chats that come in, I'll read them at the end of the stream, unless they're relevant. So, because I want to sort of get through this. This is a little bit long and drawn out, so I'll try. I'm trying to get through it for you guys.
You were going to read her rights again, but that we had to talk about that, referring to the autopsy.
Best evidence.
Sustained.
Do you recall making some comments to her prior to reading her the rights?
Objection. Best evidence.
Overruled.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Objection. Relevance.
Overruled.
One more time.
I assume that's not the first time you've read Miranda to a suspect.
Objection. Proper question.
Objection.
Sustained.
Let me go back to the first question then.
Yeah, just done that first time.
Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled as relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection. Proper.
Sustained.
How long have you been with the Sheriff's Department?
Since 2015.
You already said
How long
this.
have you been a
12
homicide
years.
detective?
6 years.
Okay.
Well, it's got nothing
Have
to
you
do
ever been
with
trained or told to ask or not to ask?
whatever.
What
I
is
was
that?
gonna say, well, it has nothing to do with reading somebody their Miranda rights just because you talk to them. It's situationally dependent.
Yes.
Okay, are they in point of fact under arrest? Because if they are under arrest, then yes, you Mirandize
Yes.
them. But if you're just standing there talking to somebody, even if you tell
Interrogating
them,
them.
even if you tell them that they are detained, now does it behoove you at that point to read somebody their Miranda? Sure, but you are not required to until they're under arrest. So whether or not she's sitting there talking to her about, do you believe in flat Earth? Why is the sky fucking blue? You don't have to fucking Mirandize somebody for that.
No.
Again, this is
But
just
if you
another
start-
example
you
of this
start
guy
asking
reaching.
them-
Right,
But if you start asking them questions
Right.
related to this case,
right.
you might want to
It would-
Mirandize.
It would behoove you to do so, correct. But if they start making spontaneous utterances or until you place them, you're not required to until they're placed under arrest.
Yeah.
That's SCOTUS has ruled on that.
Yep.
So,
But
and it doesn't matter
he's
what their
tried.
policy is, right? But he keeps going back to this policy thing, or to state law, or to the state constitution. All of that is irrelevant. State law, state constitution cannot supersede U.S. law or the U.S. Constitution or ruling by Supreme Court. Cannot.
Exactly. That's why whenever they got rid of Roe v. Wade, a lot of people lost their mind,
Yeah.
because now they states have control and autonomy to be able to make rules however they want them to be.
Exactly. Because it was interpreted incorrectly to begin with and was never a constitutional issue.
Exactly. And so, and even Ginsburg said the same thing. It was like, this is bad law. And if you want to change the law, then pass the law and change it federally.
Yep.
Which means you have to get both the House, the Senate, and the President to sign off on this.
Yep.
If you can't do that, then states can choose however they want to interpret this and take it up with the states.
But
Get it out.
again, it goes back to what we were saying before. He's just throwing shit at the wall to see what sticks. So
Yeah, but see, she was not. Here's the thing: arresting officer. They did not arrest her at the time.
Right.
They read her Miranda rights whenever they talked to her outside of the vehicle. They read her Miranda rights whenever she was inside the vehicle. They read her Miranda rights 3 times that I can count.
Right. Yeah, to my knowledge, yeah. And whether or not she signed, like I said before, whether or not she signed, they went over a waiver and she signed it, is irrelevant. Whether or not she asked, whether or not she understood, or anything. All you have to do is have the primary elements as required.
Or primary elements.
Right.
That's it.
That's
4.
all you have to have.
And the judge has already read that off.
Yep.
Any
But he
statement
keep-
or questions prior to reading Miranda relating to
Oh, what was that?
Nothing. No, I was just going to say, but he keeps trying to test the waters and push the issue. So, but anyway.
Yeah, he will. Throughout this whole thing, that's all he's doing.
them talking to you?
Sustained.
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and I wish to have a conversation with her.
Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Overruled.
I did not ask her question number 9.
Okay. Do they have a Miranda cards form in the interrogation room? So you would have had that on your person?
Yeah, they had to take the camera off of her. They're just like, yeah, so hot. Like the camera is just like, she's looking at me now. Realize he's zooming in all the way in on her face, and he's got it like focused on her mouth. And he's just like sitting there, drools running down the side of his mouth. He's just like, oh, she's looking at me now.
I feel dirty. I want to have a
Let's go
fluffing
back
in my
to the
region.
pudgy one. But we must go back to the pudgy one.
It's like looking at her and thinking, baseball, baseball, baseball. Grandma, grandma. I'm so mean.
He's stupid.
Yes, this is our waivers and affidavits.
Yep.
Is that filled out of waivers and affidavits?
It's filled out by me, but there's something highlighted that I did not do.
Oh,
Is that form filled out as it relates to Sarah Boone?
We're talking about just this top, right? Okay, I'm sorry. It does it what?
Does that form, is it filled out as it relates to Sarah Boone?
In the case, yes.
Is that her signature below?
Yes.
You see her sign it?
Yes.
Is that your signature below?
Yes.
And is that the consent for the form?
The consent to search, yes.
On that form, is there also the Miranda warnings?
Yes,
That is a form that's standardized by the sheriff's department.
yes.
And you did not read a Miranda from those rights?
From this piece of paper,
Yes.
that's audio and video recorded, that, no,
You would agree that.
Oh,
yes.
Judge would like to.
oh, the smirk. That had to kill him. She just looked up at him and was like, yeah? And then did a little hair flip. Oh, so cute.
Same objection to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the
Old
detectives.
horn dogs.
Again, under
Yes,
the case
DJ.
law, there's no requirement for this question 9. Under any state case law regarding Florida's state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the Fifth Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her paper from Miranda rights.
Response.
Bam.
Judge, obviously we disagree.
Then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean,
Yes.
State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed the Florida Supreme Court decision. I'll talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that, Judge.
The right to remain silent, the right to an attorney, before and after questioning. If you can't afford one will be provided to you. Everything you say can and will be used against you. Those are the things that Miranda highlights. That Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell, and then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state, identify what's required, and that's not one of the requirements.
She has a duty.
She fulfilled
to
her
read the
duty.
rights.
But they were.
I want to finish my argument.
Okay.
She has a duty.
She fulfilled her duty. She did her
fulfilled her
duty.
duty.
That is all she is required to do. The policy means now. When you go back to this policy thing, granted, yeah, policy is not law.
Yes.
Policy does not supersede. However, can it look bad? Certainly, it can. It
Yes.
can put potentially reasonable doubt into the minds of the jury. But this guy is hammering, oh, she's got a duty. Oh, but the law, blah. No, you're wrong. That is not the law. Their policy is not law.
Yeah,
She fulfilled
policy is
her
not
duty.
law.
She fulfilled the requirement. That is all that is required.
What the sheriff's policy is, that their policy is based on law. Okay. Whenever they have a policy, and this goes for any policy that is made in any sort of department, government or otherwise, like your employer probably has a policy, more than likely, that you're not to be grabbing women's asses while
Right.
at work. You're not supposed to reach over and goose the girl, that's bringing you your coffee. You're not supposed to be doing that. Well, if it's your wife, maybe you might be able to get away with that, but they don't want you doing that. That's their policy. Now, their policy is backed up by law that says if you do that, then you go to jail for sexual harassment. Okay? You can be arrested for sexual harassment. That's based on the law. But they have a policy for that. So just he's trying to get this out, and the judge is not having none of it.
He's trying to equate the two, and it's not.
Yes.
To read the rights. She has an obligation to ensure that
You did.
Sarah Boone understands her rights by asking that question. Do you understand the rights I just read?
No. It's not part of
And
it.
then there must be a waiver. Yes, I understand the
But she
rights,
didn't.
and I agree to speak to you now.
You don't have to have this magic word.
So for that
No.
to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with a detective is she reads the rights, do you understand the rights? And then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me?
It's not required.
How many times? Let me ask you this. And if I was a judge, I would be so much fucking meaner than he is. The judge is very kind, because if I was the judge, he'd go, are you telling me that Sarah Boone has never been arrested before and she's never had to have her rights read to her? Because I don't know how many documents Here, I've got a stack of her rap sheet that shows how many times she's been arrested. Are you telling me she's never been read her rights? So she has no idea what she's saying can be used against her. Is that what you're trying to tell me?
Yeah.
The problem is with Sarah, she thinks she's smarter than everybody else.
Well, and I don't know if it's come up recently, but I know there was some hubbub about it a couple of years ago where there was some discussion or thought about even doing away, because it's such common knowledge as to what your rights are, of even doing away with Miranda rights, and in as far as for the requirement of them by law.
Right.
Where that stands, I don't know. I haven't delved into it or whatever, but that was, I know, something that had come up a couple of years ago or whatever.
Yeah, that's.
So it's not like she doesn't know.
Right. No, she knows. But he's like you said, she is grasping. He's grasping for anything that he can to try to get this thing thrown out.
Right.
He's doing a good job, except he's losing.
Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the sheriff's department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify
what you
about
perceive,
what she
but
perceived
not
at the
what
time that the detective failed to read that question.
It doesn't matter what you perceive or what anybody perceives. It's what the United States Supreme Court, the Supreme Court of Florida, has said. These are the 4 standards that you have to meet. That
question and how it ties into the case. I understand that all they have to read is those 4, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know it was an honest mistake. She had an old card.
No, it wasn't
But
a
still,
mistake.
no,
I feel like
no
it should
mistake.
be
She got
considered
all
in your
4.
decision.
It's not a
Anything else, Mr.
requirement.
Chair?
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as relevance by virtue of the decisions in Thomas 351, Southern 3rd 197, and Owens 41, Southern 3rd 352. There's, it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Exactly. Done. See you.
Do you
Bye.
agree, detective, that after you read her those Miranda rights,
And there was a screw up in the recording of this. It wasn't me. It was actually them that had an issue. It crapped out on it. It'll come back here shortly. This was on the court's side.
What did I say? I said something earlier when he was at this point, and I can't remember if it was after or before this part. Something to the effect of, it's like watching a short bus commando flail around in the water, and the only thing keeping him afloat is his helmet, or something like that. I can't remember.
Oh, yeah. Yeah, I know that feeling. I'm the short bus commander. Ask anybody on the YouTubes. They know me. Hey, I ride the shut bus.
situation on the 25th, when you were reading her Miranda and about to question her, was different from the situation the day before when you read her Miranda in the squad car?
Yes, I had more evidence.
That was
he had
without
more
the
information.
autopsy. That was without the 2 videos from her phone in the squad car.
Yeah,
Yep.
at the time of the interview. Yes.
And in the squad car, she was free to leave.
Yeah.
I mean, I didn't tell her she was free to leave, but I mean, if she didn't want to talk to me, she didn't have to talk to me.
There you go. I want to see the
And
interview. in the
lo and
squad
behold. You want to what?
car. I want to see her interview in the squad car.
Mm.
You can sit in my driver's seat anytime.
Well, and I think that's part of where his beef is and where he's trying to go with some of this, is because of conversation.
That's all the questions I have at this time. Thank you.
Prior to
redirect?
the
Okay.
squad
All right, can this witness
car
be
and
released?
being on
I
audio
like-
or videotape.
Yeah. Yeah. Well, and that stuff will be brought in also, her initial statements,
Right.
because she was read her Miranda rights then also.
Yeah.
Your statement.
All right, subject to recall. Thank you.
Oh, and they're going to cover a whole lot more. Guess what? Sarah Boone's going to come up to the stand here pretty soon.
State, you may call your next witness.
No additional witnesses or evidence in this issue, Judge.
Okay, all right. Anything from your side of the ledger, sir?
Judge, I would like, you stipulated to the introduction.
No, I don't object to the authenticity.
All right, Judge, I would like to introduce.
I-
Just that.
If I was the judge, I tell the attorney to get on with it already. No, the judge understands that this is going to be difficult. He's fighting an uphill battle. Okay. The judge is going to be a lot more considerate to this attorney than he would be elsewise. The reason why he will be is because, one, he doesn't want to have a freaking appeal. Okay. He does not want to have an appeal, so he's going to let this guy, battle this out as much as he possibly can. He's going to let him have his time, because all it takes is him saying, "Yeah, we're not going to hear any of this." The judge easily can say, your argument isn't valid or whatever. And that's all he's doing right now. He's trying to get all of this crap done before they show up in court. Okay. All of this has to be done before they even select a jury, because once court starts, he doesn't want any surprises.
Yeah. And it's game on. Yeah.
Exactly.
And we've seen some judges, and I'm going to knock on wood, and I hope, I don't think that he would fall in that category. We've seen some judges, though, who are afraid and will hem and haw and kick stuff around and, oh, well, we're gonna delay or what have you, because they're not sure where the standing is necessarily with case law or what have you, because they're so afraid of it. And I don't think that this judge would necessarily fall in that category. I think he has balls enough to make a decision and to go with it, and whatever it may be in the end as far as potential for appeals, so be it.
Right.
So I don't necessarily foresee, so far with this judge, I don't see that as an issue.
Yeah, because I mean, initially, she had her own attorney. Not initially. I think she had a court-appointed attorney, and then ended up having her own attorney for like a couple of years, if I'm not mistaken. And I think at some point in time, she pissed off that attorney enough that he was just like, okay, I'm done. Like I'm withdrawing from this case and I'm out, because he couldn't get any momentum on the case, because if you're an attorney, you don't want to spend years on a case like this. If it's necessary, you can do that. But if you've got a difficult client and they're not willing to play ball, now that there's things that they haven't brought up, more than likely she was offered some sort of deal. I would imagine that they probably offered her some sort of deal.
I would be very surprised if she wasn't. Yeah.
And she just like wanted to be difficult, and they're just like, okay, I'm done. I can't work with you. You're not going to work with us. We're not going to work with you. We'll move on. We'll just go ahead and try the case. Well, then she fired that attorney. And of course, whenever she fired that attorney, or that attorney left, then she's got to have representation. So the court appoints an attorney. She applies for it. She gets another attorney. That attorney, if I'm not mistaken, had a conflict. So then it comes that she gets another attorney. Each of them have conflicts. Then she ends up with one for a good period of time. He makes some pleadings and filings. She ends up becoming difficult to work with. He asks to be removed from the case because she's being difficult. The judge warns her, says, this is not going to continue on. We understand that, some of these people had conflicts and they couldn't represent you, but you're not going to just go walking through attorneys like this left, right, and center. That's not going to happen. And he said, if you continue it, you're going to be doing this pro se. She went through 2 more attorneys after that could not, they couldn't represent her because they represented witnesses or new witnesses or something of that sort. They conflicted out, and she ends up with Cashman, I believe was the last one. She had a female attorney that comes in. She says, yes, I've worked with difficult clients like this. not a big deal. And after, I want to say it was several months of Sarah's shenanigans, she's like, okay, I'm done. I can't work with her. She's not listening to what I tell her to do. She's on her own. And the judge agreed. Judge said, okay, you've gone through your last attorney. We've got a court date set for October 7th. And it's up to you to get representation or not. Outside of that, we're moving on. You're going to do this pro se. I warned you exactly what would happen if you continued. I warned you the dangers of being pro se, and she continued to play her bullshit.
Mm-hmm. Yeah.
It's been since 2020, dude.
Yeah.
Like,
it's been over 4.5, going on the better part towards 5 years. I mean, this shit should have been over with a long time ago.
Yeah.
To be honest.
Yeah. 2 years at most.
What is it that's been marked as Defense Exhibit B?
Yeah, there's a bunch of crap that happens with this. Yeah, good for the judge. Absolutely. She's used 8 different lawyers. Yeah. And like I said, there's only been, I think, 4 of them that she's been able to use.
Is it the form as of now, or is it the form as of 2020 when the...
I think this is lawyer number 9.
Okay. Can I see it for a moment, please? Thank you.
Yeah, it's so convoluted with her on that.
Any additional argument with regard to the state's relevance objection?
Right.
Yeah,
No, I'm sorry, Mr. J, I wasn't specific enough. Mr. Owens, to you. Any additional argument? All right, I'm going to sustain the relevancy objection for the same reasons the court articulated previously.
Today you have German Unity.
And Mr. Owens, you have one additional exhibit as well.
This is a composite exhibit, judges the following.
He just leaned over to her. He's like, are you okay? She's like, I got denied. I'm gonna lose so bad. I guess I should have taken that deal when I had the chance. I guarantee she's gonna come back and say, Judge, it's gonna sound something like this.
Oh, Judge, can I accept that deal now? Because I know I lost.
Do you have a relative that comes to this channel on Sundays? No. Well, I won't admit to that. He's an asshole.
Yeah, you got to be careful of that guy. He's a really dangerous guy.
He follows me around all the time. I can't get rid of him.
He's a stalker. I try to keep you two separated because
I know.
I've seen the fights you get into. And I don't want to be in the middle of your internet drama, so you guys just stop. Don't talk about that. That's internet drama. We don't do that.
Yeah. And the board meetings. Oh my God. Oh, they're horrible.
Well,
arguments.
Just base meets board.
I'll see Mr. Chair support.
Wears all your clothes, eats all your food.
Right?
Sex with your wife.
Do you know what page specifically
Such an
those
asshole.
policies are on?
Page 14 of 22. I'm going to give you 2 more pages.
Is it beginning of paragraph 4, waiver of constitutional rights?
Yes.
Hey, at least he gives good hand jobs too,
With the ever so soft, sweet mumblings of a banjo in the background, wafting on the breeze.
Okay, I've read pages 14 and 15.
And so butter's
All right,
my
Judge, and then,
biscuit.
Go to 13 and 28.
13?
13. It's the next.
Oh, there's 2 different sets. It's a composite. My apologies.
It's split up.
Got it.
13 of 28 at the bottom, P. And then it goes on to the next page, 14 of 28. Specifically 2A on 14.
Oh God. skip some of this stuff. Like, blowjob later? Blowjob. You're like, all right. Gotta get paid somehow. Do you do a
Anything
rim
else?
job?
No other argument, Judge, other than what we talked.
Anything further? Okay, all right. I'm going to overrule the objection as to relevance as to what was pre-marked as composite C. And that'll be received into evidence over objection as states 1. I'm sorry, defense is 1.
This is a counterpoint. Yeah.
Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Ms. Boone can approach the podium.
Yeah, she has
And
to,
I-
she
and I
has to
guarantee-
do this.
Yeah, I guarantee you she was insistent on it, and he's just kind of like, okay, whatever. Otherwise, she's
And you've
just
already
going
been
to
sworn.
scream and
Counselor,
holler
you may
and kick
proceed.
her tiny feet over it.
And would you please state your full name?
Sarah Boone.
Well, you're going to have to speak up or move the mic.
Sarah Boone.
Yes.
That smirk.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back.
I think their sound man's got their microphones confused again.
Yeah, it just, and we've said this before, and a lot of people in here, anybody watching or listening knows that it seems like this has just become more and more. Why are we having so many of these freaking audio and video problems in 2024? It's just absolutely amazing. I mean, you go back and you watch stuff from like Ted Bundy's trial when he's up there doing his stuff. Or, I mean, stuff back in the 80s and 90s. And O.J. Simpson. And how clear and great it was. But now, all of a sudden, we seem to be having all these freaking issues. I just don't get it. I don't understand.
I do. I can explain it. It's really simple. Back in the day, they actually had people that were audio engineers. Okay. Now, because well, these people said, "Hey, I could do audio. I could be a total audio engineer." And they apply for the job because daddy works somewhere in the courthouse, probably in records or some crap like that, or mommy does. And they say, "Oh, look, there's a job opening, son. All you have to do is go apply for it." Sweet cheeks. All you have to do is go in there and you can apply for it. It'll be easy. All you have to do is dial some knobs, turn some knobs. You'll figure it out. And then this shit happens because they've got the lowest common denominator idiot that knows nothing about what they're doing that got put in that position. Yeah, the good audio engineers are not there anymore because I guarantee you, if I was an audio engineer for this crap right here, they would not be having these problems at all. Like you know your equipment. Number two, you know what's exactly going on with. I mean, I think my audio probably sucks tonight. I don't know, because I can't hear it. But if you're sitting there and you're operating a mixing board, you know what it sounds like. You know where the mistakes are. You know where your EQ is supposed to be set. You know how to dial people in. You're able to control it. It like a flick of the wrist. I mean, you can pretty much set it and go if you know what you're doing. This person is an idiot. More than likely, they came in from TV to run sound.
Yeah, it's just amazing to me.
Yeah.
Back to the morning of finding George Torres in the suitcase.
Yeah, she's 40. Looks like
You
she's
called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
Very confused. It was very hazy.
Yeah, very confused, very hazy because you were hungover from drinking all damn night.
Wow. I don't think that's
Didn't
much
understand
different than
the
any
monuments
time
on my people that
previous
were
or
there
even
and-
today.
Yeah. I don't understand anything that's going on around me. Oh, wait until you see her come running up to the cops whenever she's there for something else. Hey, how's it going? Give me a hug. The cop's like,
Alcohol and wet brain's a hell of a thing.
Yes, it is.
What they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home.
Boone.
I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge, move to strike. This is outside their motion to suppress. They have not made any allegations that our statement was involuntary because of a mental state or state of intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation was the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the day before the interrogation.
Yes, this judge is so on it right now. He is so on top of it. I love it because he's just like, whoa. Objection, Your Honor. This is way outside of the scope. This and the judges, I agree. This is not 20 questions and then you have some sort of surprise. This is going to become very important here in a couple of minutes while he's questioning.
Interrogation.
I understand that.
We're not talking about an intoxication.
Are you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
I'm going to sustain the state's objection.
Relating to the intoxication?
Yes.
Yes.
It wasn't raised in any of the 3 motions that have been filed.
Judge, I didn't ask her that. She volunteered.
I understand it. Objection sustained and stricken.
Did you speak to the deputy?
Oh, that judge is on it. He goes, oh, not only is that objection sustained, all of what she just said is being stricken. Like, done.
Yeah.
About what had happened?
Yes,
Okay. And then were you asked to stay on scene?
by both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the 2 detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? Was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Copesall asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Copesall.
How did you unlock it?
She handed it to me and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
Did you ever see the phone again?
I did not.
Okay. After that incident, was the next time you were spoken to by Detective Copesall was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you recorded on your phone from the night before?
No.
Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes,
Were you allowed to leave the scene at that point?
I was instructed by those to not
Okay. And how long did you stay on the scene?
the entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
At some point, did they all leave?
Yes,
And at some point, did they tell you they were finished with the work there at the scene?
yes.
What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right. And how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband? And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Kopsel?
I did.
And whose phone did you use?
Former husband, Ryan Boone.
You said your phone had been seized?
Correct.
And you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Hopeful told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And
I see. I'm not used to police protocol because, well, one, arrested. Number two, I don't know anything about this. So, because none of that was discussed in any of what I saw. So, would it be common that the police would just say, "Come down to the station and pick up your phone later"?
Yes.
Okay, so it's not like they would say, "Oh, we're gonna drive over there and drop off your phone to you."
Yeah. Unless there was something else that was going on, some other extenuating circumstance no. Typically it's, you can come down and pick up your property, whatever it may be.
Yeah, like, here's my number, give me a call, or just show up.
Right. And in that case, usually, and at that point in time, that was before they even knew what was on the phone. They had no idea yet what was on the phone. So then under that circumstance, then it would make more sense for them to turn around later on and say, yeah, well, go ahead and come on down here. And we need to talk to you about something else. Because at this point, from how I'm reading it and seeing it, prior to her getting there, they're putting their ducks in a row. They know what the video is. They already have in their mind what's going to take place because she said it the detective said it on the stand. Either way, she was not going to be freely leaving that day, whether she chose to speak to them or not. Once they got her down there, which makes more sense if you can do that versus using SWAT or something else, because then you run into a situation of creating an issue, creating a scene, barricaded subject, whatever. It's much easier if you can get them to come to you at that point in time. Then you have control of them because they already knew she wasn't going to be leaving.
They sort of let her go at the end of the night because they already had her phone.
Right.
And they weren't expecting to find anything on it.
Correct. Yeah, they had no idea what they had at that point.
Right.
It wasn't
until after she left, they were just like, oh, crap, we got this stuff on there.
Mm-hmm. So it makes more sense
that
they would change their mind.
It would make sense to me that we've got to take a little bit of time. We're going to download whatever we need to off your phone. I mean, it could be anything. She could have been calling for a hitman to come over or calling for someone to come over because they don't know what is on the phone.
Mm-hmm.
Like they're looking at her as, okay, you went to sleep and this guy locked himself into his suitcase. Sounds weird, but okay. I mean, people do weird crap all the time. I mean, you would not believe the weird shit that you find out about people.
Yeah.
So there's a possibility that whatever she's saying may be absolutely true because you're taking their word for it, but it doesn't leave them out as a suspect. But she's freely giving you answers. She's answering all your questions. She's handed over her phone. She doesn't seem like she's a threat to anybody. It's not like, they show up and she's got a smoking gun or something like that. They show up, they find a dead body. They ask her some questions, just like, yeah, we were playing hide and seek. He crawled in there. I went to bed, woke up the next day, and he was still in there. I don't know what happened.
Mm-hmm.
At that point, you're not suspecting any sort of foul play. I could imagine them saying, yeah, go home and we'll be back in touch with you. But yeah, you're going to, if you want to get your phone, come down to the station tomorrow.
Well, they know that it's a homicide because regardless of the circumstance, anytime you're dealing with a body, it is automatically viewed as a homicide from the beginning until all the ducks are in a row and until you can figure out that's how it is viewed. So they know that there's a homicide. They just don't know exactly
whether it's a
where
suicide
things-
or
Right.
whether she did anything
Accidental,
or somebody else did
otherwise,
something.
but, I mean, they got a body, so
Right. They could have easily been looking at her husband too, you know?
right,
Like,
right.
but then once you see what's on the videotape, you're like, oh, she's the only one there besides this guy in a suitcase.
Yeah.
Like, it looks unreal whenever you see it. You're like, you're telling me someone's in there and they're moving around. What the hell? I mean, that sort of blows your mind away. If you haven't seen it, it's cuckoo. And I've got the video uploaded on my channel, I believe.
Is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Copesel's private cell number?
All right, so make the case. Show your ex-husband's cell phone, the phone call that it was made from. But they haven't done that.
She gave it to me before she left the scene.
And did you call
As
her?
they would do.
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
So that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay, you were concerned about the case and you wanted to call her.
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her in all honesty that I felt that she was trying to trick me.
Sustained.
There's a red flag right there. In
Did
all
you
honesty,
have a conversation about your phone?
Yes. I asked her.
Oh. You may answer the question, ma'am.
Your head out of the way.
Yes or no? She said yes, and now I don't know what's pending.
There is a spelling bee channel.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me if I remembered about when I was being pregnant. And it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion?
Or there's a possibility she said, you just come down tomorrow, whenever. And she probably asked her, I noticed you were pregnant and how's the baby doing? And I'll be your bestest friend. And I can tell you all about how it was with me and my child. I can tell you all about it because I went through the same thing and chatty. And of course she's just like, yeah, just come down tomorrow. It's fine. Well, I have all these questions. Tell you what, write them down in a notebook and ask them whenever you get here. I see that more likely as a conversation that was happening.
Yeah.
Like I can almost guarantee that the detective was just like, I'm tired. Like, I don't want to talk with you. Like, bring it down tomorrow. I've been on the job for, 12 hours. My feet are tired. I'm just done with you.
And who knows? I mean,
Question
it can very easily be one of those things too, where that could very well be. I mean, that's just the way it goes. But you're going to appease them. You're going to appeal to them. You're going to say to lull them into a false sense of security or what have you. And in her case, it worked.
Yep. She's smarter than the rest of us, man. She was spelling bee champion. I will say that she does have some very good handwriting. Like, everyone's like, I can't even read her handwriting. I'm like, I have no problem reading it. Much better than mine. If you saw my scrawl, you'd be just like, oh, good Lord. Like, I'm looking down at it going, what does that say? Is that an A or is that an E? I can't tell.
Interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Copswell was pregnant and not feeling well? So the next afternoon, did you drive to the sheriff's department?
Okay.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see. And they, I guess, rang them upstairs, and Detective Lowen came downstairs. And I thought I was supposed to be picking my phone up over at a particular window. And he says, no, your phone is upstairs. So we would just like you to come upstairs, and that's where you can pick up your phone.
All right. And so did he escort you upstairs?
He did.
How did y'all get upstairs?
In an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants.
His firearm was on his waist?
The entire time, yes.
Okay. So y'all got off the elevator. Where did you go from there?
He brought me into a very small room and they had me sit down. And then from there, I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator,
I think the point that they're trying to make, and then they may try this in court, is that she saw the firearm and was in fear for her life.
Yeah, she was scared. Yeah,
she was scared because he was wearing a firearm.
Yep.
Sweetheart, if you're scared because someone's wearing a firearm, then keep your ass out of Florida, Georgia, South Carolina, North Carolina, Texas, and any other place that has an open carry. Okay? Because, well, geez Louise. You might want to avoid like police officers too, constantly.
Yeah. Yeah.
Because
they're trying to make it sound like it's a surprise, especially the sheriff's department or the police department. Or oh my God! Oh, there's firearms all over. They're just gonna jump up and start going off.
Oh my God! I'm
so scared.
I was scared for my life. We need to use it.
So it's just a dumb.
Can we use this as defense? Because I think it'll be okay, wouldn't it?
Mm-hmm. Yeah.
Yes.
Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else prior to that time. Was there any discussion that you made outside? Any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No.
Okay. So directly off the elevator and walked into the interrogation room, and then we've got the video on that. Now,
it was the red rum elevator. Two twins jumped out and blood was going all over the place.
You and I've watched the video, correct? And you've seen the motion where I referred to the question where she asked you to sit down.
Whispering something about play with me.
You recall that happening?
But no, they were writing red rum, red rum, red rum,
red rum, red rum.
Yes.
Did that refresh your memory watching the video?
Yes.
Mm-hmm. She didn't want to watch it.
Do you recall her saying that she had received the autopsy?
Yes.
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
Yes.
This was prior to you being read your Miranda rights.
Correct.
And she also said, we're not done talking about the incident. You recall that?
Yes.
And then she said, we just have to do it.
Yes.
How did that make you feel?
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
In every way.
Were you trying to cooperate?
In every way.
Were you polite with them?
Very.
Did you break out your knee pads every time? Did you use your tongue every which way? I did everything I was supposed to do. Yes, Lisa, it is at 1.25 because it is a little bit draining whenever you play it really slow.
Mm-hmm.
And I don't want to be here for, 6 hours like it was last night.
Yeah, I heard that was a little long for.
a little long,
Yeah.
dude.
I only caught part of it. Like I told you before, I can't do the political stuff like that anymore because
So check
freaking
this
pisses
out.
me off, sends me over the edge.
This thing was up to here last night. Okay, that's where it was at. That gives you any idea.
Yeah. Well, I could tell you were feeling good.
Yeah. Oh, I wasn't feeling any pain until this morning. Whenever I woke up, it was just like my wife was like, your alarm's been going off. I was like, what time is it? She's like,
do it live.
That's not me. She goes, "Is that it's?" I think she said it was like 5 till like 6:25 or something like that. I was like, yeah, I'm going to be late for my stream. I'll get up, make some coffee. I have to have my coffee. But yeah. that's why I was lit.
Yeah.
We don't do that often. Just saying. I'll tonight I've had 1 shot, 2 shots. I've been sipping on them and a couple of beers. But yeah, that was last night was, no, not on a weekday. Don't do that.
And when she said that, we just have to do it. You said just like we did yesterday.
Yes.
And then you said normal protocol.
Yes.
Is that what she had said the day before?
What do you mean?
Normal protocol.
Yes.
And she said the same word. You said normal protocol to her.
I was reiterating to her what she had said to me the day before.
So she read the Miranda rights to you.
Except number 9.
Except number 9. She read the rights and then she said, do you understand what I've just read to you? And you agreed that you had.
Yes.
But you were not read having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
It's
I was never
irrelevant.
asked that.
Doesn't matter.
You already
need to
said the
be.
key words that she was read her Miranda rights. That's all that
Yep.
matters. That's all that matters.
Your first bottle. You just emptied your first bottle. Yeah. I don't drink during the week usually like that. And
way that
even
she
on the weekends, I hardly ever drink
acted,
like that.
the things that she said, the fact that they
Get your shit together, Owens. God. No, and I will say this. Has your wife informed you all witnesses in Florida State Court are entitled to $6 per day? You'd be incorrect, James. You'd be incorrect. If you're in a federal court, that might be the case, but if you're dealing with a civil action, generally, no, you're not. There would be no reason to do that. It would be too much to keep up with, and it would be a pain in the ass. And pretty much, if you might be entitled to it, but nobody asked for it, nobody gives 2 shits about it. So there you go. And also, I live in the state of Georgia, and I can guarantee you that that's not a thing. And the codes that you tried citing, yeah, that's U.S. code. That would be federal, completely different. So, good luck to you.
They had your phone.
Mm.
Did you get the impression you were not getting your phone back if you didn't answer the questions?
Sustained.
She was in custody?
Yeah, it's been conceded by the state in their response that it was a custodial interrogation.
Okay, but she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception matter?
Exactly.
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed small space.
That all goes to whether or not.
She was being questioned by 2 lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Yeah.
Yep.
Well, I
Got
know
nothing
some
to
of the
do with
factors are
coercion.
whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation. That I'm struggling with the connection on that being non-compliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not, based on
subjectivity matter.
Excuse me, based on
Her
subjectivity
feelings
matter.
are relevant.
Under the case law.
Yeah.
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity
Oh,
have to do with
firearm!
that?
Oh no!
And this is one of
I believe
those
this one.
things where,
Objection's overruled. I'm sorry,
like I've
objection's-
said so many times, reality doesn't give a shit about your feelings.
Nope.
Your feelings
Nope.
don't matter.
Oh, I got a firearm. Oh, and Liz, here's the thing. What this guy was going off on, he decided to Google like witness pay. And he decided to send me a Google information about witness pay. But if you look at the actual statutes, that what he was trying to quote me was coming from basically some stupid law firm in Florida that says, "Oh, you too could be entitled to this kind of pay." But yeah, that's if it's for certain kind of cases under certain circumstances. So yeah, it's witnesses don't get paid. If you're a expert witness, you get paid. But that also has to be agreed upon. That would have to be something that would be agreed upon beforehand, and usually you're going to find out that kind of crap in voir dire. As if you've ever watched a trial, like you can see that they do this in voir dire. Were you paid to be here today? How much were you paid? I make X amount of dollars per day, and I reviewed these cases. So yeah, it's just somebody trying to be a fucking troll, and they can go suck a dick for all I care. Sorry, but I'm not sorry.
Sustained. I apologize.
Did you understand you were not going to get your phone back until you answered the questions?
Sustained.
Did you have some questions for them at the end?
I did.
Oh no, police officer, where's
Did you feel like you had a choice in answering their questions?
Sustained.
Man, that day, you came to the sheriff's department to get your phone?
Yes,
Did you know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were
You
going
don't
to be
have to
questioned?
know.
I did not.
Were you
don't have to
trying to
know.
cooperate with law enforcement based on
Sweetheart, if you didn't know you were going to be questioned whenever they read you your Miranda rights, then you're worse of an idiot than I thought you were. Because as soon as they started reading your Miranda rights, here's a simple thing. I want my attorney. They ask you a question, I want my attorney. They can ask you the same damn question. They can ask you a million fucking questions, and all you have to say is, I want my attorney. And they can keep questioning you, and you can say, I want my attorney. I want my attorney. My attorney. And that's all you do the whole damn time. Did you know under Florida law, all witnesses are entitled to a funny little hat with a repeller? Well, yes, but I'm not allowed to wear that in court anymore. They get very angry at me whenever I show up like that. It's only because of the razor blades in it. I'm sorry. Sorry, don't touch the hat.
He's sitting over there
her statements
whirling
that
his
you have to
propeller
talk to us?
again. I'm playing helicopter.
Were you there answering the questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
So here's the thing. I don't care. That's the beauty of it. I don't care. Stupid to take the stand. Well, of course, it was very stupid for her to take the stand, MLS. But that's a hoe got to eat. Hoe got to eat. You know, she's got to make that $45 a day.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? And you consumed no alcohol in your home that morning, correct? So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copeslow that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copeslow that afternoon?
Now or then?
Then.
Did alcohol affect my conversation with her?
There's a jury instruction that says.
Oh my God.
Yeah. She's just plain stupid at this point. That's exactly
no.
right.
She's this attorney is slapping her down so hard because he's basically saying, "So are you saying that?" And I'm asking this for a reason, and he already knows the answer. Did it impair your ability to answer these questions truthfully? So are you lying then, or are you lying now?
She's trying to play stupid and failing miserably.
Yeah, because her attorney couldn't coach her on this. Her stupid answers.
A witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect my answer?
Oh God, it's so glorious. Just what she's trying to calculate in her mind, in this drug addled mind of hers. Now she is trying to figure out what is going to be the correct answer. So she's asking herself multiple times, oh, there's got to be a correct answer to this because I don't want it to bite me in the ass. And that's why she slowed down and she was just like, let me suss this one out before I answer it because I'm about to get my ass handed to me.
Yeah. You can see the smoke.
And she's going to add
ears. Yeah.
Oh yeah. It's just like, it's a fucking attorney.
Judge, I don't think she understands.
I don't. It's been asked 3 different ways.
Bullshit. She knows exactly.
No, she understands.
Yeah.
She's trying to come up with an answer that's not going to get her in trouble.
Yeah.
But she done got herself in trouble. Oh. Love it.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she didn't know what. She said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
Grinding.
I know that she said she didn't know
What are the legal grounds of your objection? All right, you may proceed.
All right. And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct? Do you understand that the score sheet minimum is probably about 22 and a half years? Okay. And it is your desire to have these statements.
Dude, you're an idiot. Okay? And I'm going to tell you one last time, lay off of it. Because I know what you're trying to do. You can go suck a dick. Okay? And I'm giving you a warning right now because you continue on with this shit and I will remove you. You'll be timed out. It's really simple. If you don't like it, go suck a dick. Happy to know you.
It's excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
Judge, I would object to that. I'm not understanding what the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Copeslo's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination, that both state attorneys and defense counsel and the state's expert witness today. It is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1. And therefore, she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon. Response.
Yep.
I agree with the impeachment about being under influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison, 22 years on the low end. I agree with all that. We just got through at the jail meeting with the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, and he's pushing himself potentially to be a witness down the road, I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020? Yes. And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
Excellent.
And so you understand the benefit of this motion to suppress being granted?
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger? Okay. Anything else from the state other than argument?
Just argument.
Okay. All right. Once Ms. Boone's seated, we can proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided.
Removed.
Mr. Owens, is your motion, sir? You may proceed.
Yep. All that crap that she's trying to pull, it ain't working.
Judge, my understanding of the law regarding Miranda, first issue was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video.
Oh.
And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use.
Or maybe they're trying to figure out exactly what happened. I mean, there could be any number of things that they're trying to figure out. Weird how that happens. You're saying, okay, you're saying that X, Y, and Z happened, and I'm trying to suss this thing out, and she's willingly giving up this information. There's times where they say nothing during that interview, and she just, she cannot shut up. Just goes on and on and on.
I've never actually watched any of her interviews.
Oh, I've seen it. And once she realized, once they showed her the videos, oh my God, she just starts rattling. And the officer in the red shirt with firearm that's sitting there, and he's just like, He doesn't say anything. She just yep. She cannot shut up.
Use at trial to impeach the defendant and convict him. The law allows law enforcement at that stage to use deception, to lie, to trick.
Nope.
We found the murder weapon. It's got your DNA on it.
Not what they
The
said.
co-defendant has come in here and confessed and implicated you.
It's not what they said.
All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, it can be utilized to obtain a confession or an admission of guilt.
But they didn't do
But
any of
prior
that.
to Miranda, you cannot deceive. Prior to Miranda, you cannot trick.
What?
What is he talking about?
Right is fundamental. You cannot be compelled to incriminate yourself.
Correct. You can't be
You cannot
compelled,
be
but the
forced
Supreme
to
Court
talk.
has
It's
ruled
gotta
on
be
that,
free
that you
will.
can use deception. You can use those means and manipulate. You can do that. Now, do I necessarily agree that somebody makes a statement to law enforcement and they can come back later on and charge them with lying? Not necessarily. But in point of fact, Supreme Court has upheld that. And it doesn't, it's not just, oh, you're only allowed to do it prior to somebody being Mirandized. No. That's a lie, number one. Number two, from what I've heard from other people and from what you were saying as well, in this case in particular, since I have not watched any of the interviews, it's all irrelevant.
Yeah, it is. Like everything that she says is,
matter.
yeah, it doesn't matter because she already was Mirandized.
Correct.
Like she comes in, everything before her being Mirandized, they can't be used in court of law. I mean, but she doesn't say anything incriminating before that. The only time that she says anything incriminating is after her rights are read to her, after her Miranda rights are given to her. That's whenever she starts to ask her questions. She answers questions. Well, how much did you have to drink tonight? Was it a little bit? Was it a lot? How did he get the suitcase? I mean, these are base questions. I mean, some of the questions are just like we're just trying to figure out what the hell happened.
Well, even
You're
the waiver
saying-
form, even the waiver form that he keeps going on about, that could be up to a department in their policy potentially. But for a lot of places, that's a formality, like I said before. That's not even required.
No.
All it
There's only
is an
four
addition
functions.
to a paper trail, evidentiary procedure. That's all that adds to. But it is in and of itself not required.
Oh no, not this is his whole argument.
And a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement to correct that type of misuse behavior.
But you have
It's
to
illegal.
prove that that's what they did.
Right. And
So
she
you
did
got
her due
Detective
diligence
Counsel
by giving
on the
her
one
own.
hand.
Exactly.
I got to read your rights. And you have a right to remain silent. But within a minute before,
Stop with the dramatics, you ass.
the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing.
No, it's not.
That's deceptive. There's nowhere in policy that should be allowed or is allowed.
Yes, it is. Supreme
Yes, it
Court's
is.
ruled on it, dumbass.
Yes, it's called your Miranda rights, you dumbass.
Supreme Court has ruled that those techniques can be utilized. Reading of Miranda is irrelevant to that.
Majo, you have a wonderful good night-o to all you listeners, and sorry to turn your channel over with Pumpernickel. Anytime, man. Anytime. Pumpernickel. At least it's better than Schooner.
Schooner.
No, you're absolutely fine, Majo. You're doing just great.
No.
You're welcome anytime. And you have a wonderful evening.
There's nowhere in the law that should be allowed. It's actually illegal to tell a suspect We have to talk to you. We just have to.
It's not illegal.
Before reading Miranda rights.
No.
That is an
not.
illegal statement.
No, it's
Sarah
not.
Boone did not have to talk to them about the autopsy. Sarah Boone.
See, there's the word language that you're screwing up. We need to talk to you.
Yeah.
They never said you need to talk to us. You need to tell us. They said we need to talk to you.
Well,
And
even in
see
that
how he
case, there's
changed the
there's
language.
no other type of threat behind it. You're going to talk to us, or we need to talk to you, or we're going to tie you up and whip you with jumper cables and hook you up to a battery, or some
Stop,
shit
you're
like
turning
that.
me on.
I know. Well, that's why I paused for a second because I started getting excited. But no, there's nothing coercive in regards to that nature at all.
No, because
Like I
they're
said, the Supreme
saying
Court's
we
ruled
need
on
to
that.
talk to you. She shows up and she's spilling her guts.
Yeah.
And they've read her Miranda rights. It is completely different. And this is the problem with him trying to do this, is because it doesn't look good for him. It makes him look like an idiot.
Yeah. Well, and it goes back to what we were saying too about
what happened.
About the spontaneous utterances or excited utterance, or however you want to phrase that.
Right.
At that point, prior to being Miranda, does it behoove you to Mirandize them at that point in time? Yeah. However, that spontaneous utterance can still be used.
Yep.
But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it.
No.
Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
Oh. But the statement of "we have to read you the rights" was made before "we have to talk to you." So your argument transposes those two things chronologically.
Why even have it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses.
He's trying at least. I'll give him that.
A traumatic event. She lost her boyfriend.
No.
I'm coming to get my phone.
He wasn't lost. We knew exactly where he was.
Yeah, he was pretty easy to find. All he had to do was unzip the suitcase.
I mean, he was already packaged up and ready to go. I mean, all they had to do is just pick him up and throw him on the gurney. And I mean,
well, they didn't even have to pick him up. I mean, he was in fetal position. They could probably stuff him back in the womb at that point.
Yeah, that's what I'm saying.
Oh. I mean, this is a horrible argument, and this guy is obviously going to lose this because he's a dumbass. He's a serious dumbass. I mean, he's trying. At least he's trying.
Yeah.
Unlike some attorneys I've seen that they don't even.
Yeah. I mean, you got to give it to him. I
phone.
mean, he is doing that. So.
Oh yeah.
And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it.
Again, we need to talk to you. You don't have to talk to us. We need to talk to you. That's us doing something. You don't have to do anything. Big difference.
And then she reads the rights. Right there within a few seconds of each other.
Yep.
That's improper. It's illegal.
No,
it's coercive.
not.
No, it's not.
No, it's not.
No,
It
it's
forces this not to be a valid waiver.
No, coercive would be saying you need to talk to us and then reading them their rights and saying, if you don't talk to us.
And or stating or implying some type of,
that if you don't talk to us, it's not going to, that we're going to do X, Y, or Z. If you don't talk to us, then we're going to do this, that, and the other. That is coercive.
And again, he brings up the waiver. They don't need the fucking waiver. You don't have to have somebody, okay, I want you to read after you Mirandize them or whatever. All that is just a formality. Some departments, like I said, can vary. That may be part of their protocol and procedure, but is it required by law? No, it is not. It is a formality. It is a paper trail. It is part of the evidentiary proceedings to show. But they don't have to do that. Here, take this, initial next to each one of these, blah, 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 sign at the bottom, date it, yada, yada. They don't have to do that.
No.
But he keeps hammering on it. Yeah.
This guy's an
Her
idiot.
other rights under that circumstance. Coupled with
Doing
the
the
fact
best he can. Sorry.
that she came down under false pretenses. Coupled with the fact she doesn't have the ninth question. If you think about it, okay, you got a right to remain silent, you got a right to a lawyer. Those 3 or 4 questions.
You were just wondering if I was a lawyer? Oh, hell no. Oh, hell no. I would never, I will never claim that ever. I will never claim that ever. I will, and the reason I say that is because to become a lawyer, there is a lot of shit that you have to go through. There's a lot of crap that you have to wade through. And it's amazing to watch my wife, which is an attorney, to watch the way that she works, because she can sit there and go through getting barred in two states. Okay. And that means that she had to pass the bar in 2 states, not just one. And we're not talking that she did one, at the beginning of her career, and then 6 months later took the bar in another state. Oh, no. She did this 10 years apart from the time that she passed her bar in the state of Georgia. And so, yeah, there's, and the amount of schooling that you go through, the amount of crap that you have to learn, the way that things need to be written, the proper way to question people, the work that she did with legal aid beforehand, just getting her toes in this while she was still going to law school, sitting down and writing briefs for people that had been arrested and, dealing with people in prison or just in the county jail. I think it was in county jail. It's completely different. I would never, that's just like saying, oh, I know medical information. I don't know shit about medical information. I didn't go to school for that. What I went to school to learn how to do was to kill people. That's what I learned how to do. I went in the military. And anybody tells you any different, then, well, they're lying to themselves. Just saying. That's what I went to school to learn how to do. Actually, it was a mechanic, but I mean, you can still like stick people in like timing belt and stuff. Painful, and you might get hurt in the process. The fan blade gets caught up, your arm gets all mangled, and that's before. But I'm rambling again.
You just call that a Robin Williams.
Do you understand what I've just read to you? I'm paraphrasing. But then Detective Copsell goes right into questioning. Once Sarah says, yes, I understand.
Yeah, there you go.
It's an acquiesce to authority. Okay, let me start asking her questions. The critical question is,
wrap it up.
Having these rights in mind, do you agree to speak with us?
No, he doesn't have to say that.
No.
The time of free choice. That is the time of decision for Sarah to be given that opportunity. But the way I understand, Detective Copsell had the autopsy. She had the blunt force trauma. Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before.
Well, Bubbles is worse.
So sure, any detective worth their salt would want a statement. She already said we had probable cause. We'd already made our mind up that we were going to arrest her. They were, if she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested.
I'm sure.
Yeah.
They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now.
Yeah.
But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive.
No,
we would ask that.
Big difference. Big difference. That's not what they said. They didn't tell her she had to talk. They said we have to. Big difference. Puts me in the mind of the what? Puts me in the mind of Kill Alice's restaurant. God.
you suppress
So
the evidence.
funny.
Any response?
Judge, the United States Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2 hour and 6 minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th, they are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kupsel's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Kupsel's. And of course, she has a bias and interest in the outcome of the case, whereas Detective Kupsel has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you for the reasons that we stated in our multiple responses to their multiple amended motions to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
Oh.
Tomorrow is a court holiday. The court has.
So dude just completely nailed it in less than 5 minutes.
Mm-hmm.
He completely nailed it, made his points. This other guy could not do it. Well, she said,
Kitty Kate.
oh
This
no,
is
she
all
hasn't even gone to
preliminary
trial
stuff.
yet, Kitty
Yeah.
Kate.
This is just
She's not
preliminary
even
stuff.
gone to trial.
Yeah. Well, the thing about Powell is, and he can't sit there and honestly look you in the eye and lie about the fact that he doesn't know better than the bullshit that he was up there spewing. That he doesn't know that that was bullshit that he's up there spewing. He can't honestly say that.
No, he can't. But he's, like I said, he's doing the best that he possibly can because he's got a difficult situation.
In the law of the case.
Response.
And just a clarification, but you know, she's here today and she's in handcuffs, so she has difficulty writing. She has,
So this right here is and here's the thing. What they're going over now, and I'm sort of skipping over this. I'll have the whole thing up later. What they're talking about right now is about her handcuffs being on her wrists and ankle bracelets being on, and they're also going over her wearing makeup. Okay, so this is going to hit a pretty dramatic ending, and there's nothing that the judge can do about it.
Let me just interject for 1 second. She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger. And people automatically will take
they
that
just need to
heart,
see the
and it will
video.
affect their decision. when they go.
No, and I'll tell you right now, there's a big difference between Bubbles and this attorney. Okay. Sarah Boone reached out and this attorney accepted her desire to have an attorney. Okay. The problem with Bubbles is he interjected himself into her case. Big difference. Whenever you have an attorney that interjects himself into somebody's case, completely different. This becomes an issue because, well, I'm not even going to go into it because I'm not an attorney, but this is the completely different situation. So yeah, no comparison.
Go back into the jury room. So yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go?
No, that's your table, sir.
That's my table, closest to the jury. So she'll be sitting here with the other 2 lawyers and I. And the only time they're going to see her walk in and out is she's always going to be in the courtroom.
They're never going to see her walking in and out.
So the only time is when she testifies.
No, they will never see her walk
So
in.
I guess I don't know if you have leg restraints that she.
How many
can wear
courts
and walk,
have you been in?
but
100.
We believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny. and she's walking from the defense table to the
It's
witness
got to
stand
have
to
the
testify on her own
dramatics.
behalf.
That's why.
But I don't think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and I assume the tables are going to stay here.
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. You know, there are times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative, and she understands the importance of behavior. And I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Anything further as to that issue?
I don't believe that's case law authority on the issue. I believe.
All right, thank you very much.
It's just case law.
With regard to your request for clothing.
And that's all that the attorney has to say is like, that's not case law. We're just going by case law here. I mean, if your honor wants to release her and have her on, I'm just telling you, it's not case law.
In that, you could certainly go to the jail and provide, have whoever it is that you want to meet with her in the meeting area to get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a person come in there to take your measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail, and it'll be transported with her.
Well, and here's the thing. In all honesty, I don't think she would wander. I think she would sit there the whole time, and she would be completely compliant. I honestly think that she would be completely compliant. The only thing is, like the prosecution said, case law says that at these kind of charges, that they have to be at least restrained, leg cuffs on. I mean, that's all he's saying. Completely different.
In the morning, each day of trial. With regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial. Just the arguments in there.
And the Estelle case that you cited spoke to being dressed out in a prison garb. Doesn't really address a prison guard in shackles. It doesn't address any beautification or anything along those lines.
Well, and here's the argument, okay? Just so you guys sort of have an idea. The argument on this is she wants to have some sort of makeup on, even if it's just like some base color, whatever it might be. She wants to have a little bit of makeup on, maybe brush her hair and make her look presentable. So she doesn't look like she just, woke up on the bad side of, prison. Just saying. So that's sort of their point, and I understand their point. It is a very valid point, but pay close attention to what the judge has to say about it.
Well,
and the judge is.
But 40 pounds of joint compound does not make up make. That's more restoration, or
Oh, but she's going to get that. And here's the thing: the judge, and I will tell you, and spoiler alert. The judge is going to say, yeah, I mean, if she wants to put on makeup, we can't do it in the back room, but if they want to do it out here in front of everybody, that's absolutely fine. But pay close attention to what the prison guards have to say.
I just think it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm going to have the two paralegals here. I say paralegals. One's a lawyer now, and the other is a consultant. But they're females, and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply anything.
You can't put them back there. We can't allow access back there.
So my question is, did he discuss this with these two females prior to making this statement? Has he already discussed this with them, or is he just like throwing their asses under the bus and now going to be saying, oh, well, because you're females, you can just go and play, Queer Eye for the Straight
Dress
Guy.
up. You can play dress up. Oh, well, I'm sure they're trying to work something out, and I understand, and I will say from the defense's table, I understand where he's coming from. It's like, we don't want her looking like death freaking warmed over. I mean, she looks bad enough as it is. She looks like she hit the brick wall and hit it really freaking hard. Can we at least make her look somewhat, like attractive and doesn't look like, doesn't look like she woke up on the wrong side of prison? And I understand that.
Yeah, but they've got they've got the drink mix packs, man. She can do what everybody else in jail and prison does. She can dye her hair with the Kool-Aid. She can use it as lipstick. She can use it as rouge, and just go in there looking like a clown. Right? Or, the other one too is just have her stand out in front of the courthouse, and you can take a paint bucket and do a drive-by. I'm
fine with that too. I mean, what? How did you know how I spend my weekends? Damn it!
Well, yeah.
Well, I do get lonely, and I like paint.
And you dance in front of a mirror and tuck, and
only. Come on.
It puts the lotion on its skin.
I was exactly going to say the same thing.
Put the fucking dog in the basket.
Put the dog in the basket.
Can the two females on the team, can they be allowed to apply some type of makeup to Ms. Smith?
State? We don't have any dog in this fight. I've never heard of it happening.
I see dog.
That doesn't mean it's not permissible,
Yeah.
but
If you want to try to do it here in the courtroom, that's fine. But be advised that, when we start court, we start court. So, and I intend on starting it at 9:00 every morning. So I'll have pleas.
Like I said, the judge says it's okay, but this changes things here very shortly.
Every morning in other matters, because the court still has other business at 8:45, and I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing. You can perhaps someone attend travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas. But if you want to attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request to removal of the leg restraints. The hand restraints will be removed.
And here comes the sheriff. Here comes the sheriff. Hold on. Here comes. Hold on. Listen.
It needs to be done in the courtroom.
Yes, sir.
Hmm.
And then
Here
the
it
last
comes.
item teed up for today is I'm sorry. Yes. Yes.
Mm-hmm.
This is really important. Barry Beret.
So corrections in the Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband. They don't know what's placed on her person. And that's the concern.
There's just going to be some facial makeup.
I understand, but
I don't see
DOC and Sheriff's Office tell me they can't do it because of the concerns that were just outlined. After she's returned to the Orange County Jail facility.
I don't care what you and the White
Yeah,
Rabbit
with regard
say,
to-
expert. You'll never get me to stop loving blueberries. Not that you're hurting my feelings. You don't.
I
care.
love it.
Whatever.
I love you guys. I love you guys. No, you heard what the judge just said? The judge just told him, no, we do not allow that.
Mm-hmm.
She cannot come back to the court. She cannot come back to jail wearing makeup because the concern is she has some substance on her face.
Mm-hmm.
We don't know what they're putting on her face. We can't allow it.
Yeah.
Like this is their
There's always
policy.
that potential. Yeah, there's always that potential. I mean, there are security issues for a reason, and why rules are made for a reason. I mean, you find people putting shit under people's stamps in their letters or on the inside where they hide that stuff and put it in all manner of places. Not to mention that, as weird as it may sound, whether it's a jail or prison, all kinds of things get used. It's not back in the day when they used cigarettes for making deals or buying things and shit. It goes to other things too. I mean, we've had inmates who you're supposed to sit there during med time, for instance, and watch them and make sure they swallow the meds, right? However, aside from what can be brought in, we have inmates where they will swallow the meds, but then when they go back to their cell, they'll throw them up. They will induce vomiting. They will throw them up. They will dry them out. And then they use that medication. A lot of times they'll crush it up and you snort it. And especially if it's an extended release medication for a reason, when they snort it, they get that different high, that almost instantaneous, kind of like with snorting coke. And they use that shit to pass around and pay for stuff. You see that all the time. Or there'll be, or you'll see
medical advice here. Just by the way, there's no medical advice.
What you'll see is, them fishing under the doors, what you call fishing. And that's how they pass that shit around too. So there are security measures that may not make sense to people who have no clue, but they're there for a reason.
Yes.
And that's
and these are just rules that the sheriff's department has, that they have rules. Yes, I know. These are rules that they have. So unfortunately, the judge is not going to allow her to be wearing makeup. Even if she puts it on in court, if she puts it on in court, she's going to have it removed before she leaves. And they probably won't even do that because they consider it contraband. She is still a prisoner in the Florida State Prison.
Mm-hmm.
And they have to go by those rules. They can't change them.
The restraints no later than tomorrow. Moving now to the state's request for protective order. I've reviewed that. I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
Yes, my JA had emailed all y'all.
You dumbass. You filed the goddamn thing. I went over this beforehand. They filed that they wanted to bring in these particular people from the state's attorney's office, and they're just like, yeah, this is improper because it gives away all of their workflow, and this is pointless. If they want to get this information, all they have to do is do a FOIA. That's it. Freedom of Information Act. They could request that information. There's no need to call these people in at all.
I think last week after it was filed, it said this would be added to the hearing for. I guess that was filed on Monday. Forgive me. I had emailed y'all and said that it would be addressed today.
That was relating to me subpoenaing the enlisting the I think it was
it's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the Office of the State Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
But as you know, we have filed our notice of intent for private spouse murder in conjunction with self-defense. And we have listed and plan to introduce the fact that Jorge Torres had been arrested, I think, 3 or 4 times prior to this event. And I think on 3 of those cases, the case was dismissed against Mr. Torres. And it's going to come out that Sarah Boone had requested the charges be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of bail and then get the charges dismissed as a battered spouse. That's a common theme. So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their request, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons? How would that not be protected by work product?
Well,
as to whether or not it was
if it comes out that she went down there and requested the charges to be dropped, and they were
But she always goes down.
then
What
that
are you
gives the
talking
impression
about?
that she had the power and authority just to come down to the state attorney and ask the charge to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases, even if the victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it, and their power and authority to do so, not the victim's authority.
Okay. Response.
And that
And
became a thing for a reason.
yeah,
Opinion work product. That is absolutely protected. I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we're moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. I mean, the state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits they don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they've listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone.
Yes.
So all that evidence is going to come in, but it cannot be coming in through opinion work product of the assistant state attorney.
What were you saying a minute ago, Yamaha? Not even a minute ago. You had something important to say. You said, what else did they find on her phone that she does not want them to see?
Mm-hmm.
Oh my freaking God.
Hmm.
I wonder if they have a video of her, rolling that suitcase down the stairs, one bump at a time.
It would not surprise me at all. And that's kind of what I was thinking, why it's going to be so interesting to me to fully see what the ME has to say and hear that testimony and the idea of that, because I know damn well her ass didn't pick that suitcase up and drag him down there. And that was what my thought was, is that all this started upstairs and she loosed his ass down the stairs, and that's how he got those injuries. Banging his way down the banister, So, and her thinking potentially, and why she didn't have an issue, so to speak, giving up that phone, was because maybe she attempted to get rid of it and thought that it was just gone.
Yeah.
So we don't know with all this preliminary stuff. And that's why getting to the actual trials is so interesting. When it's not necessarily the lead up, because like I said, we see this and hear this all the time in the true crime arena, if you will. This shit just happened. And granted, this stuff just happened 11 days ago now. Or let me rephrase that. No.
4 years ago.
I was getting confused there for a second. Yeah. No, yeah. I was the sheriff one just bumped into my head. Yeah. But I mean, we're at this. Yeah. So, but my point is that we need to get to that point where it gets to the interesting part, because all these individuals and so forth that you see so many times in the true crime arena, well before this stuff just happens. And all of a sudden you got all these people out there espousing all this stuff and making all these, this is what and it's got nothing to do with anything. And so much of it is so far left field, it's not even funny.
Yeah.
But I don't think Holly Monster likes this. Apparently she's saying that you and I are painful. I don't.
Oh, no, I don't think she's yelling at us. I think she's yelling at the prosecutor. That's all.
Spontaneous guilty statement.
No. Holly Monster has been pretty cool the whole time.
I am a pain in the ass.
Yeah, she says putting designer curtains on the haunted house. She's not yelling at us. She's yelling at these idiots. Yeah, Sarah and her attorneys. That's all she's yelling at. She's not angry. I didn't take it as her being angry with us. I was like, I'm with you, sweetheart. I'd love to.
Attorneys and our support staff.
I just felt like busting.
Any further argument?
There we go.
I didn't make the argument.
Yeah, you
I didn't
did.
make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case.
That's not true.
Not why we chose to drop 3 cases against George Torres, but they have the ultimate authority. The victim does not control the case. The state attorney does.
You have a written order on the motion, protective order for tomorrow, by tomorrow as well. Anything else, state, we need to address?
It appears, and again, been conducting motions all afternoon. It appears that we are set to allow the defense to depose our battered spouse syndrome expert at 10 a.m. tomorrow. Yeah. And that will be done virtually.
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
That's set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes. There will likely be a pending motion to strike if his testimony is conflicted with Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here or is that taking place in South Florida, virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
Okay. All right.
Judge, and then
Yeah, so tomorrow, 10 a.m., they're going to have a Zoom hearing, and they're going to do a quick deposition of this expert witness. So that's all it is.
on Dr. Brandon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10. Paul's expert.
Is the expert going to be available at 10?
Oh my
Talk about that
God,
at the
the
jail
expert's
trial.
involved in this.
The expert is always involved in this crap. The
Yeah.
expert's going to be available at 10, just so you guys
Bring in
know.
the expert on this. She's screwed.
Check it out. The expert is going to be available at 10. You're screwed now.
For tomorrow. So she just evaluated Sarah Boone from noon to 2. And then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then we're taking Dr. Brandon's deposition. If they file some type of motion about that, then of course I'm going to respond. We're going to need to have the hearing on it.
Go ahead, I'm sorry.
Those 2 things are the only 2 things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, state if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes, we're going to be filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed. Just waiting to see now how the depositions pan out tomorrow. But based on what we witnessed this afternoon, it's the state's position that we're going to file a motion.
Okay. All right. Appreciate it. All right. Thank you all very much. We'll address scheduling of any motions on Monday. And it may be a circumstance where, as the court had identified earlier, that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn it over to you all, which would include, Mr. Owens, your opportunity to voir dire on any defenses that may be being raised in this case. So it may be we may get a panel and then ask them to come back later in the week so that we can have those motions after we get that panel of 50, once we deal with all the cost challenges. Okay? All right. Thank you all very much. We'll see you Monday morning at 9 a.m. Court's in recess. Thank you.
She just wrote a little note on the back of one of those pleadings. Like, do this for me. Do this for me. Come by my office later. Oh, I'm so happy. I'm so happy to be here. Can I wear makeup or no? I can't wear makeup. No, she can't.
I don't understand
Here's the thing.
the questions.
Yeah. So she's not going to be allowed to wear makeup, and that's really all there is to this portion of it. It is she's not going to be allowed any of the makeup that she wants to wear because they consider that contraband because they don't know what might be in that makeup. There's a possibility they could totally dope her up, or they could put arsenic in it. Who knows what they could do with it? But they don't want the makeup, and they're just saying, nope, not going to happen. Not going to happen. That she can't put the makeup on. She's going to have to wear leg restraints because she's going to be sitting at the table. That's just the way that it is. So, she won't have her arms handcuffed, and she probably won't have the waistband, but she'll have her legs handcuffed. So that way she can, waddle out if she needs to. And of course, the jury's never going to see it. All they're going to see is someone sitting at a table, because the jury will get up and leave before she does. The jury will not know anything about what's going on with her unless she makes it known. So if she makes it known, that's completely different. You need a face palm emoji. No, all you need is the Wizinator emoji. The Wizinator emoji does it all. I also have a new emoji up there, which nice helmet. But I think maybe you have to be a sub for like a amount of months or something like that. But yeah, I've got all those things up there. Anyhow, I'm going to send all you fine people over to go see MG Law and the expert. Yes, the expert will be over there. You guys give him a hard time. I will see you guys early in the morning. There's a reason why I'm cutting it off so early. I might show up over at MG's for a little bit just to, see what they're all doing, and give them a hard time. I might show a little more skin that I'm showing right now. Yes, I'm wearing a sleeveless shirt. It is my muscle shirt. Oh, like the muscles.
Oh, my muscles are getting hot.
No, it's like here's the expert. If you guys ever won,
I love you. You love me. Can I lick you where you pee? What?
Oh my God.
He looks so creepy as a 12-year-old.
Like a 7-year-old. Good Lord. No, but I will be kicking all you fine folks over there. Everyone have a wonderful night. I will see you guys in the morning. Y'all will hang out for a little bit, and
Thanks, everybody. Yeah.
Yeah, thank you. And also make sure that you go sub up to I Have a Story. That is Yamaha Biker's evil twin brother that likes to sneak into his room late at night and give him hand jobs. I mean, more hand jobs for Yamaha. So weird. Keep up.
Running through the maze, I felt the pain, chasing what only a dream, break from the scheme. Waking up at dawn, all my fears are gone, all set today, never, not today. Compromise, rise above it all, not gonna fall. Step by step I go, faster than the flow, broke through every chain, I will not be contained.